Testing, testing.
In compliance with the Open Public Meetings Act of 1975, adequate notice of this meeting has been provided. If any member has reason to believe this meeting is being held in violation of this act, they should state so at this time. Please stand for the Pledge of Allegiance.
Okay, Mrs. Werner, Mr. Venuto,
Here.
Mr. Ledwin,
Here.
Mrs. Notch, Ms. Sheehan, Mr. Walsh,
Here.
Mr. Zexer,
Here.
Mr. Cataldo,
Here.
Mr. Bodnar.
Here.
Thank you.
Okay, first order of business, we have a new member that needs to be sworn in.
Mr. Bonner, I try not to torture people and make them repeat after me. Can you just read this out loud?
Yes, I will. You want me to stand, or may I sit?
You may, however you're comfortable.
I, Steve Bodnar, do solemnly swear that I will support the Constitution of the United States and the state of New Jersey, and I will bear truth, faith, and allegiance to the same and to the governments established in the United States and this state, under the authority of the people, and I will faithfully, impartially, and justly perform all the duties of the office of Zoning Board of Adjustment member according to the best of my ability, and I will not use my office to grant preferential treatment nor to seek personal gain, favor, or advantage not available to the general public, so help me God.
Thank you, sir, and thank you for your service. If you could sign that for us, and we're throwing you right into the fire because there's only 6 members here tonight, so you're voting, so
Okay.
good luck.
All right, first order of business is we need a motion to adopt the minutes from August 24th, 2023.
Motion?
Second.
Okay, we have a motion by Mr. Ledwin. Was that seconded by Mr. Walsh? Thank you. Mr. Ledwin?
Yes.
Mr. Walsh?
Yes.
Mr. Zexer?
Yes.
Mr. Cataldo? Mr. Bodnar?
Abstain.
Mr. Venuto?
Yes.
Thank you.
Okay, next order of business is motion to adopt the resolutions. So our first one would be 9/28/23 Christine Glazer Carlson, or Christine Carlson Glazer, 710 Columbia Avenue, Block 1071, Lot 3.
I'll make that.
Second?
What's that, Mr. Zexer? Seconding?
Yes.
Thank you. We have a motion by Mr. Walsh, seconded by Mr. Zexer. Mr. Ledwin?
Yes.
Mr. Walsh?
Yes.
Mr. Zexer?
Yes.
Mr. Cataldo?
Yes.
Mr. Bodnar?
Abstain.
Mr. Venuto?
Yes.
Thank you.
Next resolution will be 9/28/23 Fern and Kevin Waters, 1218 New York Avenue, Block 1131, lots 11 and 12.
Motion?
We have a motion by Mr. Cataldo, seconded by Mr. Walsh. Mr. Ledwin?
Yes.
Mr. Walsh?
Yes.
Mr. Zexer?
Yes.
Mr. Cataldo?
Yes.
Mr. Bodnar?
Abstain.
Mr. Venuto?
Yes.
Thank you.
Okay. Next, we need a motion to adopt 9/28/23, number 3 Zoning Board of Adjustments 2023 annual decisions.
Motion?
Second.
Mr. Zexer motions, Mr. Walsh seconds. Mr. Ledwin?
Yes.
Mr. Walsh?
Yes.
Mr. Zexer?
Yes.
Mr. Cataldo?
Yes.
Mr. Bodnar?
I'll abstain.
Mr. Venuto?
Yes.
Thank you. It's all good.
All right. Moving along to our applications. There's been a change in the itinerary, so we're moving the second application to number 1. So they'll start off would be Mary Ann McLaughlin and Scott Muraka. Did I say that correctly? Okay, so and they would be at 1009 Kearney Avenue, Block 1097, lots 8 and 9. Okay. Introduce yourselves here.
Thank you, Mr. Chairman, and good evening, everyone. Andrew Catanese on behalf of the applicants, Mary Ann McLaughlin and Scott Marika. They are both seated to my left, along with our project engineer and planner, John Halbrunner. The subject property is located at 1009 Kearney Street. It's an existing undersized lot in the R3A zoning district. It's currently developed with a single-family dwelling with what we often refer to as sort of a missing tooth layout, where it is substantially set back from the road, unlike anything around it, with non-conforming rear and side yard setbacks. The owners would like to demolish the home, build their new single-family home, and we think this offers a number of significant improvements from the existing conditions, but we are requesting a few variances. First, lot area, lot width, and lot frontage. Those are all existing non-conforming conditions that result from the isolated undersized lot that exists as it sits today. Second, the proposed design calls for aligning the new home with the adjacent houses left and right. Now, the zoning ordinance permits this as a matter of right under certain circumstances. It permits it as a matter of right when you have 4 houses on a block. There are only 3 here, so we can't do it as a matter of right, but we think that it makes sense to line these houses up with the properties left and right, and we're asking for a variance for that. Second, we're requesting side yard setback relief to an open deck and stair on the left side of the house, and you hear from Mr. Halbrunner on that request, though I'll say that the overall setbacks really exceed what's required from the zone. So that's an overview of the variance relief. That is the lot area, width and frontage for the lot, front yard setback to align the house, and side yard setback limited to those stairs. We're planning to present only testimony from Mr. Halbrunner. If we could swear everyone in case we need
In case there's a
testimony,
question or
right, and any questions that need to be answered.
I'm also going to swear in our board engineer. Do each of you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. I do.
Thank you.
Thank you. I know Mr. Halbrunner has been before the board before. We offer him as an engineer, an architect, and a planner. No, you're, as an expert in planning, yes. Not a licensed planner, but an expert in planning, yes.
Yeah, we'll accept.
Thank you. Okay, so, Mr. Halbrunner, I'll let you do your thing, starting with an overview of existing conditions.
Okay, the site doesn't exist, as you mentioned in your opening statements, is in fact an undersized lot. It measures 44 foot wide, and it's 90 feet deep for a total of 3,960 square feet. For context and comparison, the minimum lot size in the R3A zone is 6,250. So we are challenged by having a lot that's less than 63% of what the required lot area is.
Excuse me,
An older 2-story home.
can you turn your mic on, please? Thank you very much.
Is that better?
Thank you.
Okay. Should I start over again, or did you catch enough of the first?
I can't tell. We're recording audio and YouTube, so
Okay,
Summary, the lot is only 63% of the size required. Go ahead.
there we go.
Got it.
Thank you, Mr. King. It's currently developed with an older 2-story home that's tucked back in the corner. It's tucked so far back in the corner that the existing side yard setback on the east side is only 1.6 feet. Its rear yard setback is only 2.6 feet. For comparison, the required side yard setback is 8 feet, where we're 1.6. Required rear yard setback is 25 feet, where we're 2.6. So clearly, the existing home is tucked tight in the corner, much more than the zone would otherwise anticipate or allow. It's got an unusually large front yard as a result of being tucked so far back. It's tucked back 45 feet from the front property line, where 20 foot would be the minimum required normally. Again, for comparison, the average for the block is 10.9, and we're set back some 45 feet. The first floor footprint is non-conforming. It's only 706 square feet. The ordinance has a minimum requirement of 840 square feet. The building, as it sits today, the ground floor has on the order of just shy of a 7-foot headroom, and its finished floor is below the design flood elevation. Pretty much paints the picture of what the existing conditions are, unless you think I missed something.
No, I think you've got it. Thank you.
Okay. Now, what we're proposing to do is construct an entirely new home. It's going to be a modest 1,580 square foot home, 2 stories. The first floor will contain, hold point to sheet P1, which is submitted as part of your plan set. It's the exact plan that was submitted with the plan set. Mr. King, I'll let you decide whether you want to mark it as an exhibit or not.
I'm sorry, that's already in the packet?
It is.
Does not, unless you write on it or something, does not.
Okay. So referring to sheet P1, which is Ms. Fines, who's the architect for the project, her floor plans, the first floor is comprised of 3 bedrooms, a family room, and a laundry room, and most notably, a rather large front porch. Second story is an open concept living room, dining room, kitchen with a master bedroom and ensuite, a powder room, and again, a rather large porch and covered deck. The siting of the building, which is really one of the reasons we're here this evening, is we're trying to align ourselves with those buildings that are on our block. We're proposing a 13-foot front yard setback to the porch. That does require a variance, and I'll get back to it.
These are the plans. That was an earlier draft up here.
That was,
Yep, this is exactly what we've got.
allow me 1 second to confirm that the characters I described are still current.
Okay. Fortunately, we didn't mark the other one, so I know.
Yeah, we didn't mark it, and I'll represent what you have here is precisely what was submitted with the application.
All right, so what everyone's looking at in their hand now is what you're showing the board.
Correct. I think incidentally, Ms. Fine at the last minute couldn't make it tonight. We scrambled and put an extra set. I think, John, you may have grabbed an older draft.
Must have.
You had another architect laying around.
We had another architect laying around. We just kind of polished them off and brought them out. There you go.
Okay, so I can represent that the number of bedrooms and the use of these spaces I described are still accurate with the current set of plans. So what we're proposing to do is site this building 13 feet from the front property line, measured to the front porch. The setback to the building itself, the actual enclosed building part, is at a conforming 25 feet. We're doing so for several reasons. Most importantly, to be more compatible with the neighborhood, and that we are effectively aligning ourselves with each of the other houses that are on the same block of the same street frontage. Again, the average for the other houses on the block is 10.9. If we were to keep it in its current location or push it back any further, that missing tooth description that Mr. Catanese described would continue today. And that's not encouraged by either your ordinance or by the HPC design standards. In fact, as Mr. Catanese had indicated, if we had one more parcel on this block, then as a matter of right, we could have the front yard setback that we were proposing, presuming that other lot was similarly situated compared to the other houses on the block. If you have 2 contiguous lots on either side of you for a total of 5 lots, you're allowed to take the average, and we'd have only 4 lots total. We're missing that extra lot. But when you take those averages, what we're proposing is entirely consistent. It's also entirely consistent with the Cape May HPC guidelines, where they strongly encourage this placement of buildings in a similar alignment as that of the rest of the block of the neighborhood.
So, John, those guidelines, these are part of the recently promulgated new HPC design standards, correct?
Correct.
And in fact, they state that primary buildings should have similar orientation and relationship to the street, and state that they should match the character of the neighborhood in terms of a number of things, including setback.
That's correct. So what we're proposing, while it does in fact require a setback variance, it's actually honoring the intent of the ordinance and the HPC standards. Sure. Mr. Catanese is going to pass out some photographs. We'll mark this as Exhibit A1. Thank you.
And actually, there are 2 photographs here. We'll mark as Exhibit A1 and A2.
Can you just tell me what they are, like photos of the front of the home?
Exhibit A1 is a view looking parallel to the street along the front porches. Exhibit A2 is a view of the home, and Mr. Talberner will talk in a little bit more detail.
I just need one word to put next to the exhibit. Is it view of view?
Let's see. A1 is
So rear view is view parallel with the street. A2 is a view.
of house and adjacent property.
Okay, thank you.
So with Exhibit A1, we're looking down Kearney Avenue. You can see that there are 3 houses that are in general alignment. The one the furthest is actually closer to the street than the front two. What's not visible in this picture, however, is our house.
Got it. So as we look at Exhibit A1, you see the first house, that's the corner property.
Correct.
At Queen, correct?
Correct.
The second house that we see, we could see the porch, and that would be the home that'll be next door to the subject as proposed, correct?
That is our western neighbor, correct?
So is the proposed porch going to line up with that second porch that we see in Exhibit A1?
Yes.
right.
Actually, a little bit behind that, but in the same general alignment.
Okay, so it'll be generally aligned or maybe set back a little more than that?
Correct.
And then further along, we see the house which is on the corner of Madison and Kearney, correct?
Correct.
And that has a setback of,
3.1 feet.
got it.
And in fact, not visible in this photograph, but recently completed on that last house in this picture is a garage. And that garage, well, maybe it is visible there, okay. If you look in the open gable of the middle house, you'll see a slight gray angled portion. That's actually a garage that was recently constructed. That's going to be to our immediate east. So the houses that are going to be our immediate neighbors are that garage and the house in front of that, whose setbacks are very comparable to one another and virtually the same as what we're proposing.
Great, thank you.
Continuing along the description of how we're siting the building, we are, I'll say obviously, reducing, although not making fully conforming, some of the setbacks compared to the existing building. The side yard setback, which is just over a foot on the west side, is being increased to 10 feet to the building, 8 feet the roof overhang on the east side, on the east side. And on the west side, we are required to have a minimum 8-foot setback. We're almost 11 feet to the second story part of the building, 13 feet to the first story of the building, but we are only 6 feet, hence 2-foot encroachment into an open, property line. This enclosed part is set back some 11 feet from the property line. And the stairs that we're talking about are set back to the edge at 6 feet, where 8 feet would be required. On the east side, again, we're slightly over 10 feet to the building proper, 8.83 to the roof eave, some 2 stories above. The rear yard, which is presently just over 2 feet, is made a fully conforming 25-foot. So we're greatly enhancing the rear yard view corridors. It's not often that I can describe a building siting that requires both a front yard and a side yard setback variance and represent to you that it creates more light, air, and open space than the ordinance would otherwise normally allow. And we arrive at that primarily for 2 reasons. First of all, we have to acknowledge that the open stairs and the deck are relatively transparent in terms of light, air, and open space. And the encroachment we're talking about is only 2 feet on that, and that encroachment is entirely open for purposes of light, air, and open space. The predominant mass of the building, the enclosed part of the building, has greater setbacks than what the ordinance would allow on side to side. It's a significant improvement over what's there today. In fact, compared to the existing building, which has an aggregate side yard setback of 12.73 feet, we're increasing that to 14.83 feet, counted to the roof eaves, not going to the enclosed building. We're actually going from 12.73 feet to 21 feet. We are significantly enhancing the side yard open air corridors. Not only that, but it's better than what the zone would otherwise allow. If we had conforming 8-foot side yard setbacks for each yard, or 16 feet total, there would be 16 feet total of open side yard area. What I'm going to call our effective aggregate side yard, effective because I am discounting the stairs that are open, we're at 21 feet. So in terms of light, air, and open space, despite the fact that we are seeking setback variances, we are actually, A, improving the existing situation significantly, and B, we're better than or effectively better than what the ordinance would otherwise allow. There's an interesting mitigating factor here, furthermore, on the western side yard setback, and I'm going to refer now to Exhibit A2, which was handed out momentarily. This photograph depicts the current house, you can see tucked way back in the corner, and the property in the left of the photograph would be to our west. The side yard setback that we are proposing this 2-foot side yard encroachment into is happening to the property that's on the left of the photograph, which you'll see has a significant setback to its own building. There is a 2-car wide driveway setback for the property line, some probably close to 10 feet. So the effect that a side yard setback encroachment may have on a neighbor is greatly mitigated by the fact that this neighbor is set so far back from the property line. Now, the property to our left and our right, they're both identified on the historic registry as contributing structures. So those footprints and those buildings, we can expect to stay there virtually perpetually. So the mitigating circumstance I just described can reasonably be expected to stay there perpetually.
And John, the HPC design standards you talked about before in terms of a consistent front yard setback also talks about consistency in orientation and spacing, that is distance between buildings.
Correct.
So this sort of centers that visually between the buildings a little better, doesn't it?
It does. It does a wonderful job of promoting a more consistent, uniform streetscape, which is something that the HPC design standards strongly encourage and essentially require. I think so. There's 2 variances that are related to existing nonconforming conditions. That all relate to the lot size and area, lot width and frontage. Those, I think, clearly fall under the C1 criteria of a hardship. They're existing conditions. There is not available land for purchase. In fact, the applicant approached the neighbors to the west in hopes of acquiring additional ground, and their offer was rejected. So we're stuck with the lot size that it is. We can't change that. Nothing about this application increases that degree of magnitude. So it's an existing non-conforming condition that we have a hardship preventing us from otherwise complying. Under the same vein as a hardship, if we were to conform to the required 25-foot setback in the front, the view of the neighbors up and down the street, view of the applicants up and down the street would be severely curtailed by the placement of the adjacent buildings on either side.
John, can I just pause you for a second? I admit I got a little distracted by the plan, but I heard you say the word hardship. It got my attention. Are you trying to make a C1 argument at the moment?
Actually, Mr. King, we're going to advance both C1 and C2s, yes.
Can you just start over with that? Because I don't have any notes that would go to a C1. Can you just start over?
Absolutely. Under the C1 hardship, we have an undersized lot that is legally existing with no opportunity for gaining additional ground to make the lot conforming. Nothing about this application exasperates the degree of that nonconformity, and we don't have the ability to make it better. So in terms of lot size nonconformities, that's a hardship. We can't do anything about it. Furthermore, if we were to comply with the 25-foot front yard setback requirement, as the ordinance would otherwise require, there would be a hardship upon the applicant in that their views of the streetscape would be severely curtailed due to the proximity of all the other neighboring properties and their siting on the street, or siting being much closer to the street.
In other words, because the other buildings around them have non-conforming front yard setbacks, to push these folks back would impair their property.
It would, yes. And it would, again, continue the missing tooth description. There are also elements of the C2 criteria that I think apply, and there are multiple purposes of the municipal land use law that are being advanced by the application as it is presented. The first is subparagraph A, which promotes the public health, safety, and welfare. We're replacing a current non-conforming home with a conforming home. We are taking subparagraph B, securing safety from flood. We're taking a building that is currently below the design flood elevation and replacing it with one that is fully compliant. Subparagraph C, promoting light, air, and open space. Again, we're eliminating significant side and rear yard setback nonconformities. Subparagraph I, we're promoting a desirable visual environment resulting from the improvements to the site and the new structure, as well as its siting on the property being more consistent with the neighborhood. And we're promoting the historic district by aligning the house with surrounding properties in compliance with HPC standards. Those are all purposes of the municipal land use law that, in my opinion, are being advanced by this application. So I think there are elements of both the C1 and the C2 that address the positive criteria for the variance that we're requesting. Insofar as the negative criteria is concerned, in my opinion, the relief can be granted without substantial detriment to the public good, and without substantially impairing the purpose and intent of the zone plan. If you consider the variances that we're seeking, what are the potential negative effects? Front yard setback, the negative effect of us citing it where we're proposing, there's absolutely no negative effect. In fact, it's all positive. Similarly, the side yard setback, as I described in my previous testimony, while we're seeking that side yard setback variance, we are actually providing more light, air, and open space than what would otherwise be allowed as a matter of right. And there can be no ill effect of that. So clearly, there is no negative to speak of, and the positive that I outlined, I think, significantly greatly outweigh those potential detriments. For those reasons, I think variances can be granted.
Anything to add? Any questions for Mr. Halbrunner?
Yeah, I have one question. On the landing and the steps, what is the actual purpose of those steps over on that side of I guess, the western side of the house?
Because the house is relatively small, the applicants use the outdoor decks as living space, probably more so than the indoor space. And as they have guests arrive, the direct path from guests arriving to the deck is a much more straightforward and beneficial path for them. Secondly, you may notice there is no rear door in this house. There's no rear deck. There's a way to get out the back. Access to the outdoor showers, which you want to have more of a private path to.
They don't want to walk around the front.
Correct, exactly. So this provides that path for them. And there's even an element of providing a second means of egress. While it may be not necessary, it's important to the applicants to have that opportunity. Quite frankly, Mr. Chairman, when I first saw the application, that was my first question as well.
John, and in fact, the stairs are, the front stairs are recessed into the building. Or
They
into
are.
the deck, right?
They are, yes.
So that sort of eats up some of that porch.
It does. And it actually is a better alternative to having those steps extend out towards the front, which you could conceivably do, but that would be a far less visual preference, and simply not be nearly as nice as kind of tucking them along the side.
So your plan is to have the porches align, right? Porches, the new porch will align with the existing porch of the neighbor, not the stairs.
Substantially aligned. He's allowing for some.
But it won't align with the stair. The edge of this new porch will not align with the front of
We'll align with the deck itself.
the deck itself, and then you'll have stairs going down.
Well, and in fact, these stairs are recessed into the
Gotcha.
porch, right? So they won't even be hanging out, right, John?
Right, I think Mr. Walsh was concerned that we're taking the setback to align with the neighbor's steps, not their deck.
Right.
And no, it's aligning with the deck itself.
And physically, the house would effectively be kind of centrally located on the lot?
It will be. We have a 10-foot setback to the enclosed building on the the east side. We have 11 feet on the west side. The deck itself is 6 feet. So it's certainly much more center than it is today.
Right.
And visually, especially given the large side yard to our western neighbor, it's going to appear, for all intents, center of the lot.
And all of that intended to have it appear very similar to the other houses, which would conform with HPC, and therefore the setback becomes less of an, in your opinion, less of an issue because of the need to be able to position it that way.
Correct.
And John, so the record is clear, those stairs that do encroach that 2 feet, the roof doesn't carry out there, there's no coverage out there, so they're
Correct.
actually lower, they don't go to the full height of the building.
That's a good point. Yeah, the second stairs in the deck, the encroachment ends at the second-story deck level. It doesn't go all the way up to the roof. And again, all that encroaches is open, unenclosed, not under roof.
I have a question regarding the proposed structure. The front of the structure, you indicated that the neighbor's garage is not indicated in the photographs. And I would note as well, in the application, it's not in here either, which I realize it's obvious construction was going on at that point in time when the photos were taken. Can you tell us where in relation on the lot the front of the house will be in relation to the garage?
It'll be effectively at the front of that garage. And I say effectively, I'm within a foot or two. On my way here this evening, I actually drove by and visually saw the very thing that we're presenting on applicant A1. And that garage is essentially in line with all the other buildings.
John, you had testified, there's a little, you could see the front of that adjacent garage with a little angled roof, basically, right?
Yes.
So if we look through the opening of the porch immediately to the west of the subject, we see the angled roof of the garage next to the proposed property. Does that clear it up a little?
Yes.
I'm not going to tell you could strike a string line and they're all going to be touching, but they're all in the same general alignment within a foot or two of each other.
And if I could follow up on that, then by way of the proposal of the placement of this house in the lot, you're going to be moving that essentially to the left of where the garage would be. There'll be more space between where the present house is located, even though it's coming forward, but there'll be more space between where the present house is located and the proposed residence.
Significantly more. The side yard setback of the existing house on the eastern side, which is the side with the garage that we were just talking about, is just over a foot. We're increasing that to 10 feet. So that neighbor's going to greatly benefit from a much larger side yard than what they presently do.
I just dug through my file. Exhibit A3, the garage next door. And what's not shown in that photograph, John, is the fact that the house to which that garage is accessory is set back 3 some feet.
Yes, something less than 4 feet. To be exact, the house that the garage is attached to, is set back 3.1 feet.
Subject to any other questions? That's
Yeah, any more questions?
I have a question. I presume the house is going to be air-conditioned?
Yes.
Where are the condensers?
Air conditioning condensers are shown over top the shower, which is on the western side of the building. If you refer to the sheet P1, you'll see at the bottom of the stairs, there's that for shower enclosure. The air conditioning condensers on top of that.
Okay.
Any more questions? Craig, would you like to give your review?
Absolutely. Good evening, everyone. I'd like to summarize my memorandum dated September 13th, 2023. This is a project located in the R3A Medium Density Residential District. Heard testimony from the applicant specifically indicating what they're proposing to do, and essentially demolish an existing two-story single-family dwelling that's oriented in the rear corner of the existing lot, and provide a new single-family dwelling with 4 bedrooms, a total of 1,584 square feet of habitable area. So that's the proposal. With regards to completeness, there were waivers that were requested from providing the utility layouts. I did support that at this point, but that information should be provided as a condition of approval to make sure that we can adequately service the house with sewer and water. So based on that recommendation, I did support deeming this application complete. To summarize the zoning requirements and the variances that have been requested, this is an existing non-conforming structure on a non-conforming lot that's being replaced with a new non-conforming structure on a non-conforming lot. They're making the argument that it's an existing undersized lot with regards to lot size. The lot size requirement in the district is 6,250 square feet, where 3,960 square feet exists. They've argued that there's no available land, so that it's an existing non-conforming situation that they can't remedy or make better. Also along those lines, the lot width and lot frontage requirements in the district are 50 feet, 44 feet is the width and frontage that is provided. Very similar argument there. Now, with regards to the structure, they're making the argument that this is to replace the house at a new location is a better zoning alternative than what exists now. So in this case, the building setback line is conforming, and they argue that this is a missing tooth, like it's set back, which is unnatural in the neighborhood, what they've showed the street pattern. So that setback is now 45.04 feet. They're proposing 11.33 feet, and that's measured to the nearest face of the structure, which is the stair projection. I think the stairs project out 2 steps from the front porch. And that requires a variance because 20 feet is the required setback in the district. The side yard setback. So in this case, you have a situation where the existing structure has a setback of 1.6 feet on the eastern side and 11.13 feet on the western side. Did I say that right?
Yes.
Okay. Where 8 foot is required, they're proposing the new dwelling to have a setback of 8.83 feet on the eastern side, which conforms. That's the driveway side.
Correct.
Correct, eastern
Actually,
side, and the western side will now have a non-conforming setback of 6 feet, which requires a variance, and that's measured to that stair projection that we just discussed. So those are the variances that are required. Now, when we look at those, they gave you the positive criteria. I always like to take a look at the negative criteria because applicants tend to gloss over that and not emphasize that. So are they overdeveloping the lot? So we look to our floor area ratio. So the massing of the house is at 0.40, which is the maximum permitted. Now, are they doing this to maximize the square footage of the house? They're maximizing it, but they're only gaining 171 square feet between the existing house, and so they're not gaining a whole lot of square footage in the house by doing this. Are they overdeveloping the lot itself? The lot coverage requirement in the zone is 45%, 38% exists, 41.7% is proposed. They meet that requirement. Are there any other potential negative impacts? Are they parking the lot adequately? Yes, for 4 bedrooms, they're required to have 3 parking spaces. They're providing 3 parking spaces. They are increasing the lot coverage. Potential negative impacts could be additional runoff. They've provided a stormwater management system that's connected to the roof gutters. So I think, in my opinion, they're addressing those things. That's a summary of the variances. I'll move right into the general review comments of my report on page 4 of 5. Item number 1 is a standard condition. They have to provide the first floor elevation on the plan, comply with that minimum first floor elevation, and also comply with the requirements for the flood damage protection requirements in Chapter 258. They've indicated that the existing structure is below the base flood elevation, so this is an improvement and will meet the flood requirements. Item 2 and 3 go together. We found that the design of the stormwater system acceptable, provided that they address item number 2, which just provides some additional information on the stormwater details. Item 4 is sort of rehashing the fact that they need to show the locations of the existing utility services so that we can ensure that proper services are provided to the house, and that information has to be provided on the plan and get city sewer and water department approval. 5 is the requirement to provide landscaping and vegetation plan. They have done that. We found that plan acceptable. Item number 6 is our standard requirement that after the house is constructed, we evaluate the sidewalk adjacent to the site to make sure it's not damaged during construction or pre-construction, and then anything that has been damaged or is dangerous has to be replaced to the satisfaction of the board engineer. 7, they are relocating or providing some improvements to the driveway curb cut, so as condition of approval, the applicant is required to submit plans to the city and comply with the requirements for those improvements within the city right-of-way. 8 is our standard condition that they have to provide the inspection escrow amount, and that ties the certificate of occupancy to the acceptance of those improvements. 9 is compliance with the requirements of the Cape May Shade Tree Commission, Fire Department, and Public Works Department, and we did receive those reports. Fire Department was dated 8/14/23, recommended approval with no comments. Public Works recommended approval dated 8/10/2023 with no comments. And the Shade Tree recommended approval with the following conditions. Construction barrier should be placed on the tree line on the Madison Avenue side of the property, which is the right side of the property. So we would ask if the board is able, if the applicant is able to do that, those notes should be added onto the plan to comply with that. So that takes care of item number 9. 10 is our standard condition to comply with any and all other state, county, and local approvals. 11 is providing evidence of final HPC approval. 12 is compliance with the applicable affordable housing requirements at the time of approval, issuance of building permits or certificate of occupancy is applicable. And finally, should the board grant approval, the applicant is required to revise the plan sets consistent with the conditions that the board sets and submit the requisite number of sets to the board engineer for review and approval. That's a summary of my report, and I'm happy to answer any questions the board has.
Any questions for Craig?
Craig, I got 2 quick questions.
Sure.
The site triangle, in this one picture, that fence, the neighbor's fence is there, will that affect that? What comes out
The site triangle for the driveway?
to the driveway? If you notice the neighbor's, that house that's got the garage on it is really, like, every time you go by, there's a new fence on the property somewhere. And I think there's actually another fence there, but I can't be sure. But will that affect this project, being with that fence there?
I do not believe so.
Okay, I just,
And typically, we require the applicant to address that site triangle conditions on their site. If there are issues, and unfortunately, it doesn't show that structure on this site.
Right, yeah.
So I think it's set back far enough where it's out of the site triangle, so I don't foresee any problems there.
and the storm management system. I walked by the other day, and there was standing water along the side of the house. It's very close to the property line. And of course, we had a lot of rain, but there's standing water there. Will the storm management take care of that?
So the grading shows that the house is being, that the site is being graded from the back to the front of the property, and that stormwater system that they're providing is subsurface, it's connected to the roof gutters. So anything, it looks, what they're proposing to do is provide positive outflow to the street. So there shouldn't, if it's graded properly, there shouldn't be any standing water when it's done.
If that water is coming from this property here, it should still have the same effect, though, right? I would think. The property that has the garage
Okay.
is so built now that all of a sudden I think there's water on their property that probably was not there before. Will that handle their water also?
No, this is, the requirements are to manage the stormwater generated from this site. So that's what the applicant has designed the project to do. So, but it certainly will,
Can you talk about the new ordinance that we have?
so we have a new stormwater ordinance, and I didn't reference it in this review, but it's ordinance number 485/2022. So for those of you that have taken the stormwater course that's required, they talk a lot about the difference between a major development and not qualifying as a major development. So our existing stormwater ordinance deals with developments that cross that major development threshold.
Okay.
Virtually no sites in Cape May, because the lot sizes are so small, ever come close to that. So therefore, those stormwater requirements were never implemented or triggered. This new ordinance deals with these minor developments, and it addresses grading and stormwater requirements for these smaller projects. So where nothing was required, it's now required for these types of developments.
Again, but I was actually, in my mind, I was thinking about the ordinance that we have that says that even outside of a development project, that there's some problem with the drainage, that there's a way for us to address that.
Yes, so there are provisions in here that allow, if there are complaints for an existing issue, there is recourse if a violation is found by the enforcement officer. The city can have them remedy a existing stormwater situation. So if this applicant takes care of his and there's still an issue from someone else, there is recourse for them to solve that problem. Thanks.
Any other questions for Craig?
Yes, I do. Craig, so Chief Coulter issued approved the fire safety and accessibility, correct? So we have they have the certificate. My understanding is that he based his assessment and approval off of the application. I spoke with him today, based off of the photographs that are contained in here. As we know, now there's the garage that's located on the property. There's also the fence that's located on that, I'll call it the right side of the property. Just walking past it, I know there's a shorter fence, there's a garage, and there's a stockade fence beyond that. So I guess my question is this. Knowing that the fire safety approval was done based on the photographs and not on the actual state of that right side of the property, is that something to be addressed with?
The applicant hasn't materially changed the application that was reviewed by the fire department. So,
Okay, I'm just asking as far as the assessment for the fires,
Does the existence of the garage affect any fire safety issues on the property?
No, the setback that we are proposing on that side of the property, which is our east side, is fully conforming. It's fully
is
conforming.
conforming. Okay.
Yes.
Okay, thank you.
yeah, the
Sorry, can you
variance is
repeat
on the
that?
west side.
Couldn't hear
Just-
that. Can you repeat that? I'm sorry.
Yes, the setback on the east side of our property, which is the side adjacent to the garage we're talking about to our eastern neighbor, the setback is proposed at 10.17 feet. The minimum setback requires 8 feet, so we're already exceeding what the minimum setback is on that side.
Thank you.
The question may have traction if it were on the side that we were seeking the side yard setback variance. Despite that setback variance, is there still adequate clearance? It's not a question that matters here because the side where we're seeking the variance is on the other side.
Okay, thank you.
Thank you.
Any other questions? Okay, at this time, we'll open up the meeting for those within 200 feet of the property. Beyond 200 feet? Okay.
Unless there's more discussion. Okay. Although the applicant made a little move towards a C1 variance, I think this really is a C2 application, so I'm going to ask you to vote on that first and see how that goes first. The C1, I'm not sure that covers all the variances you're seeking, and also, I have some questions about whether small lots are really a justification for side yard variances. Sometimes you just have a small lot, and then you have a smaller building. It doesn't mean you get a pass on side yard. So I'd rather just do this as a C2, because I think it was presented holistically in terms of the benefits outweighing the detriments. And the benefits that you've heard are really important benefits. The principal one is you're reducing a nonconformity, substantially reducing a nonconformity inside, in the rear, and also in the front in terms of inconsistency on the streetscape. Those are definitely a positive criteria, particularly streetscape with the HPC. That's important to them. So they've certainly provided enough positive criteria to justify a C2 variance if you're inclined. In terms of the negative criteria, although you're supposed to look for impact on the zone plan and zoning ordinance, a lot of times any issues raised by neighbors, which is part of the impact on the neighborhood, that is relevant, particularly when you're talking about side yards, because they usually impact people next to them. and you haven't heard any objections from them. So in terms of negative criteria, aside from the testimony, you haven't, aside from their testimony from their expert that there isn't a lot of negative, you haven't heard a lot of negative on the record. So if you're inclined to vote against this, that's your prerogative, and I'm not saying it'd be improper to do so. I'm just saying that when there aren't objectors, if you're going to vote against it, please establish a record for the reasons why you're voting against it, so that I have something to support it in the resolution. Because right now, the testimony is, very favorable to the applicant because there was no objecting testimony, and I do think that their witness certainly put on the positive criteria that was appropriate for a C2, to support a C2 variance if you were inclined. Now, we do have a new member, so I'm gonna take a little more time to read the, although the new member is an attorney, he was not a zoning attorney. So I'm gonna take a little more time just to go through the C2 standard, which my engineer quite gratefully puts in his report, so I tend to steal from that, although I sort of know it by heart. Craig, you did put it in here, right?
I did, on page 4 or 5.
Okay, thank you. It's always even, there you go, okay. So we're gonna go right to the C2 standard. Where it says, where in an application or appeal relating to a specific piece of property, the purposes of this act, meaning the MLUL, would be advanced by a deviation from the zoning ordinance requirements, and the benefits of the deviation would substantially outweigh any detriment. You may grant a variance to allow departure from the regulations, provided, however, that the fact that a proposed use, don't worry about that. And in addition to finding that it's substantial, we have to find there's no substantial negative impact on the zone plan or zoning ordinance or the surrounding properties. Now, what you're doing, the essence of that is you're trying to see if this is a better zoning alternative, both to what is there and to what would be complying. And they've set forth reasons why they believe that to be the case. For example, if they put the property set way back, or at least back where it would be required in the ordinance, you would still have that, what'd you guys call it, a gap tooth or something?
The missing tooth.
The missing people. I hope you get the variance, because then if you don't, then you have a house, you're gonna think of a missing tooth all the time.
Yeah.
But once they start talking bad about your house, you have to win, because then, but what they're saying is, it's a better zoning alternative to move it up. It's also consistent with our averaging. For those of you who are familiar with that, we have an ordinance that allows you to average a property based on other properties around it, but that only works if there's 5 houses. When there's only 3, you can't use it. But it still makes sense to try to keep things uniform. So that's the standard that I'd ask you to apply. So the motion I recommend being made is a motion to grant the application in the form presented by the applicant, with the variances listed 1 through 4 on page 3 of the engineer's report, with the conditions number 27 on page 2, as well as 1 through 13 on page 4 and 5 as the conditions. Does anybody have any questions about that motion I've recommended you make? Now, we always make them in the affirmative, meaning we make a motion to approve. That's not a hint as to how you should vote or anything like that, just we always make them in the affirmative. So if you say yes, then you're approving it. If you say no, then you're rejecting it. And this doesn't have a D variance, so it's a simple majority. So you would need 4 out of 6, because we have 6 voting members. So you need 4 out of 6 to succeed. Okay, any questions?
Okay,
I'll shortcut it a little more from now on, but since I was the first one and we just swore in a member, I wanted to take a little more time doing the standard, okay?
can we have a motion?
Motion.
Second? I'll second it.
Mr. Zexer motions, Mr. Venuto seconds. Mr. Ledwin?
Yes.
Mr. Walsh?
Yes.
Mr. Zexer?
Yes.
Mr. Cataldo?
Yes.
Mr. Bodnar?
Yes.
Mr. Venuto?
Yes.
Thank you.
All right, congratulations. Good job, Pat.
Thank you all for your time and consideration.
Okay, our next application would be Edward and Linda Farrington, 1012 Pittsburgh Avenue, Block 1156.
Projector.
Okay.
Okay, if you could introduce yourselves.
Mr. Chairman, members of the board, good evening. Thank you. My name is Robert Belasco. I'm an attorney at the law offices of Stefankiewicz and Belasco, and I'm here tonight on behalf of the applicants, Edward and Linda Farrington, who are both present and seated to my left. I also have with me here tonight Rami Nasser. Mr. Nasser is a professional engineer and a professional planner. I do anticipate eliciting some brief testimony from Ms. Farrington, and Mr. Nasser will obviously provide our expert testimony tonight. So with that said, I'd ask if they could be sworn and placed under oath.
Okay, if each of you please raise your right hand. Our board engineer remains sworn in. Do each of you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, thank you.
Thank you. So the subject property is located at 1012 Pittsburgh Avenue. It's block 1156, lot 13.01, located in the city's R4 zoning district. This property is developed with a single-family semi-detached structure. It's approximately 1 story in height. It's below the maximum building height. The applicant, just by way of background, was previously before this board back in 2019 in connection with an application to construct a family room in the rear yard of the property, as well as to reconstruct a paver patio. There were several pre-existing non-conforming conditions which were granted in connection with that application, and that was memorialized as Resolution 11-14, 2019:1. And I did include a copy of that resolution on our application packet for your review. So we're back tonight, and the applicants are proposing to construct a screened entry porch along the front of the structure. They are also proposing to install a generator in the rear yard. Now, the generator in the rear yard doesn't necessarily trigger any direct variance relief, but we felt it necessary and prudent to include it on the, within the application because it's a change to the site in this situation. We do require 3 variances tonight. Lot area, and I would note that the lot area is a pre-existing
Can I just back you up on that
Yeah.
last part? I want to understand it. So you don't need a variance to put this generator where you're putting it?
We don't believe so. It doesn't trigger any setback variance relief or anything along those lines. We are, we're right on lot coverage. We were below lot coverage. We'll be at 50% in connection with this proposal. I should say this, Mr. King, I'm glad you mentioned that. The generator plat room may slightly increase the lot usage ratio, but it's very modest in size. The crux of the relief we're seeking is really tied to this screen front porch, which is proposed by the Farringtons tonight.
Okay, by the end of this, when we make the motion, I was asked a question before the meeting that gave me, from one of the members, that kind of gave me an indication that they have maybe some thoughts about the generator versus the porch. So I just wanted to try to figure out if you needed any approvals for the generator or not. That's what and you're saying that it may affect the percentage of lot usage ratio?
Maybe slightly. My clients really aren't, they're not wed to the generator, so if that's an issue, they'd be willing to
Okay, well, let's listen,
withdraw that.
let's listen and see how it all goes, okay?
Certainly.
Yeah,
And then we'll decide at the end what we're.
Absolutely. I think generators, obviously, given, what's going on storm-wise, there's been some power outages in the area. We see a lot of it, obviously, on some of the boards I represent. It's not the crux of this application, but let's proceed.
You have an empty room back there too, which may help, so go ahead and do your thing.
So as I indicated, the main reason we're here tonight is because the Farringtons are proposing to construct a screened entry porch along the front of their structure. The variance relief that we do require is a lot size variance, a lot area variance. This is a very slightly undersized lot. It's 4,905 square feet, whereas 5,000 square feet is required in this zone. All of the neighboring properties are developed. There's no ability for the Farringtons to come into compliance with that lot size issue, and I would note it was previously granted in connection with the prior application. And as I indicated, the main reasons that we're here are for the variances associated with the porch. And those are associated with the building setback, the front yard setback, if you will, as well as the lot usage ratio. With that said, I would like to ask Ms. Farrington some questions. Ms. Farrington, you currently reside at this subject property with your husband, is that correct?
Yes.
I'm going to make sure they're...
Can you hear me? Yes, we do.
And how long have you owned the subject property?
We've owned it, 22 years?
2003.
Yes, and we moved in full-time. We retired about 5, 6 years ago.
So you reside there currently full-time?
We
with your
do.
husband. Now, you're proposing to construct this screened-in front porch along the front of the structure, correct?
Yes.
Can you tell the board in your own reasons what the purpose or what the reason for this proposal is, what it means to you, and why you're asking for this approval?
Well, it's kind of interesting. I have not been able to utilize going outside to eat we have a little fire pit. I can't go out there and eat. I can't enjoy the gardening at all or the visions of we have a beautiful front yard with a lot of flowers because I'm allergic to mosquitoes. So we've been going back and forth, the screen porches, should we do it, shouldn't we do it? And this summer I got annihilated with them. So we said we wanted to go follow through with it. We thought about it for the last 2 or 3 years, and now we finally said we should be able to enjoy it where we live. And we can't because of my medical issue.
Now, the porch is intended to be screened, correct?
Correct.
You're not intending to enclose this porch permanently at any point in time?
No,
correct?
we're not.
And the only reason that the screens are proposed, in a perfect world, you'd leave it open. However, because of your medical condition, the screens are a necessity, correct?
Yes, they are.
And that would allow you to continue to enjoy, or actually to start to enjoy the outside areas of your property?
That is correct.
Now, would you agree as a condition of approval to never enclose this porch, to never put up any sort of permanent fixed enclosures?
Absolutely. My husband said no more money.
Now, your neighbors, you live in a semi-detached structure. You share a party wall, correct?
Correct.
And your neighbors, they actually had considered filing a similar application,
Yes, they
correct?
did.
And they've elected not to do that at this time, correct?
Yes, and she's like my sister, we're very close. They withdrew because of money issues, and they still would like to maybe possibly do it down the road. And actually, they were coming tonight, but she just had foot surgery, so.
Thank you. I don't have any additional questions for Ms. Farrington. The one thing I would represent to the board is, as she indicated, the neighbors did intend to file a similar application. They actually consulted with me. This was initially intended to be a joint application, but because of the financial issues that they ran into, they elected not to proceed at this time. Based upon my conversations with them, and obviously what may happen in the future is up in the air, but they do intend to move forward with a similar proposal in the future. We'd obviously have to present this application, a similar application at that time. With that said, if there's any questions, Mrs. Farrington is here and ready, willing, and able to answer them before we proceed with Mr. Nasser's testimony. Okay. And I believe Mr. Nasser has been before this board several times in the past, Mr. Chairman. I'd ask that he be accepted as an expert, as a professional planner and a professional engineer.
Okay, accepted.
Thank you very much. Mr. Nasser, if you could describe the existing site conditions for the benefit of the board, please.
Yes, currently there's an existing, like a duplex, like a single-family house with a party wall.
Excuse me, can you take the microphone with you, please? Thank you.
All right, no problem. And there's like there's a front porch with where the driveway is. It's located off Pittsburgh Avenue, which is a 100-foot wide right-of-way. It's really one of those widest right-of-ways. The current house sits 25.4 feet from the front yard, from the front property line. But if you look at from the actual curb line, it's 45 feet plus. So it's the big right-of-way allows it to feel it's set back further. What we're proposing at this point is to enclose a portion of the front, which is 15.75 feet by 15 feet out toward the street. That will be a covered porch, but it's not a habitable space all year round, only in the summertime, which will have a screen porch, and we have steps on the side to get into the space. We're proposing a 15.6 foot front yard setback from the actual property line, but in reality, from the actual street, it's about 35 feet back. So if this was on a smaller street, this would feel like more intrusive, but because we have this wider right-of-way, it still would feel it's appropriately set back from the actual street. That's the proposal at this point.
And Mr. Nasser, the front yard setback, or the building setback, if you will, that's only to a small portion of the structure, correct?
15 feet of the whole structure, not entirely 15 feet. It's about 11.75 feet will be encroaching into the front yard setback.
And then the setback measured to the facade of the main structure, would you agree that that actually slightly exceeds the minimum requirement of the ordinance?
Yes, it's 25.4 feet.
And with respect to the fact that the public right-of-way here is set significantly further from the property line. I just want to make sure your testimony is clear. Do you believe that that minimizes any negative impact to the surrounding neighborhood or the public at large?
Yes, it will. It will ensure like the light, it would not affect the light air and open space because the space you have from the actual curb to even the new structure that is within the front yard setback still 35 feet.
And then, before we get to the lot usage ratio variance, the lot area, the lot size in this situation, we're only slightly deficient, is that correct?
It's de minimis. It's about 95 square feet, but I believe this was been approved maybe a couple times when they built the structure, and then when they came back in 2019, that was also approved by the zoning board.
And then the remaining variance that we're requesting approval for here tonight is a lot usage ratio variance, correct?
Correct.
And that's not a floor area ratio, that's a lot.
Lot usage area, yes.
And can you discuss that variance for the benefit of the board, please?
It's required to be 36%. Back in 2019, when they came back for the additional living room in the back, the board approved it to be 40.8%. With this proposal, we are increasing that by about 2.6% to 43.4%.
And do you foresee any negative detriments or negative impacts associated with the slight increase of the usage ratio?
I don't see that as long as they do the landscaping. When you look at the landscape, this property is really beautifully landscaped, and we are going to be sure that when this structure is built, it will stay as beautiful as it is now.
And with respect to the landscaping, the board engineer indicated that a landscaping plan should be submitted. Do you see any issues with preparing a landscaping plan detailing how this would be even more buffered from the roadway than the structure currently is?
Definitely not. We'll prepare a landscaping plan, and we'll be sure it's approved by the professionals.
Now, with respect to the variance relief, we're requesting approval here tonight under the C2 criteria. Is that correct?
Correct.
And can you identify, are there any purposes of zoning that are codified at NJSA 40:55-2 that are advanced in connection with this application?
I see a couple. One of them is to promote desirable visual environment through creative development techniques, especially with the landscaping. The structure also, it's a one-story structure, it's not two stories, so the encroachment in the setback would not be as intrusive as when you have two-story building. It's basically kind of low structure. And the other one is to encourage municipal action, guide the appropriate or use or development of all land in the states.
And with respect to building height, in this zone, a building could be constructed up to 20 feet, correct?
Correct.
Would you agree that the existing structure is 13.9 feet?
Yes.
And this proposal will not increase building height in any way or shape? or form,
No,
correct?
definitely not.
Now, with respect to the, you testified to the positive criteria. We're required to address the negative criteria. Do you perceive any substantial detriments to the public good in connection with this proposal?
I mean, usually negative criteria is when you're increasing traffic, or you're increasing, there's an existing structure that will stay here with the approval, without the approval, there'll still be a single family unit. The additional paving, or the additional pavers probably will have very minimal impact onto the drainage, so I don't see any negative impact onto the stormwater management or the adjoining properties.
And with respect to the coverage issue, which you just brought up, we are slightly below coverage as the site exists now, correct?
Correct.
And we're actually going to be increasing that slightly, but we'll actually comply with the 50% maximum lot coverage requirement.
Yes, we're at the maximum requirements.
Now, the second component of the negative criteria test, if you will, is do you perceive any, will this proposal impair the intent or purpose of the city zone plan or zoning ordinance?
No, sir, I don't see it. It's still the same use, the same structure.
And it's basically a de minimis addition in this situation, correct?
Correct.
I don't have any additional questions for Mr. Nasser at this time. Before we do open it up to questions for Mr. Nasser, I would note that we did receive correspondence from the City of Cape May Fire Department. The initial form didn't have a check on there. It was signed, although I did communicate with Ms. Keenan, and she did communicate with Mr. Coulter and confirm that the application had been approved. I do have a copy of that revised form here as well. The City of Cape May Department of Public Works also provided a review of this application dated August 17th, 2023. It was approved with no conditions. And finally, the Shade Tree Commission on August 24th, 2023 did approve this application subject to one condition. And that condition is that the tree at the corner, the tree at the left corner of the front yard be protected during construction. So I have one follow-up question for Ms. Farrington on that issue, and then a follow-up question for Mr. Nasser. Mrs. Farrington, do you have any objection to protecting the tree located at the left corner of the front yard of your property?
Absolutely not.
Thank you. And Mr. Nasser, would you agree that the plans could be revised to provide a detail or a note identifying how that tree would be protected if construction was, if we move forward with construction, if the board granted us the approvals here tonight?
Yes, we'll provide the tree preservation detail.
Thank you. I have no further questions for Mr. Nasser at this time.
Can I address the board before we ask questions? So, this is lot usage ratio is something that we don't normally deal with. It's specific to the R4 district requirements, so we don't have, it's not widespread throughout the other zoning districts. So lot usage ratio is very similar to lot coverage requirement, but it's not the same. So, and I'll read you the definition. The sum of the areas of a lot that are covered by the principal buildings, including attached structures such as porches and decks, detached garages and outbuildings such as sheds, in parentheses, but excluding patios, terraces, driveways, paved areas, and stone landscaping, end of parentheses, compared to the total area of the site. So, in my opinion, it's a ratio of the structures that are permitted on a building. I mean, on a specific lot. And it's a specific control, and it's only pertinent to the R4 district.
Would you say extension was patios and what?
So, but it excludes patios, terraces, driveways, paved areas, and stone landscaping.
This isn't a patio, right? Because it's got.
This is not. So this is a porch. So it's included in that. So that porch does raise that lot usage ratio, and that's why the variance is being requested. Now, there was a question with the proposed generator platform. There's no specifics with regards to that, but this tends to include accessory structures, and I would include that as an accessory structure. So my opinion is that proposed generator platform does affect this ratio. And that was your question when you first, that was your question to them. But I just wanted to make sure the board was aware what this control was and what it was doing. And so it's my opinion that it's the amount of structures that are permitted on your lot in the R4 district.
Can I ask a follow-up question to Mr. Nasser real quick? So, Mr. Nasser, the generator platform, was that incorporated into the lot usage calculation?
Yes, it is.
And I believe, Ms. Farrington, you would confirm that if that's an issue, you have no problem removing that from the plan?
Absolutely not. We debated back and forth, you know, and it's very expensive again, you know, so absolutely not.
I was answering Mr. King's question and just making sure that the board was aware, because this is not a normal variance that we deal with frequently.
Usually it's FAR and lot usage is.
Right, so.
I poured through the ordinance, but when we were preparing this application, it is unique. It's only the R4 zone that this comes in.
Only the R4 zone.
Okay, any questions for the applicants?
Can I ask one question? Is this sheet one from the application that Mr. Nasser was referring to?
Yes.
Okay, thank you.
Sorry, thank you.
Just want to make sure.
We could, I know you, Mr. Katniss, you had a conversation earlier. We can mark it as an exhibit if you want. I mean, I think it's certain, thank you.
I can't see them.
I have a question. On the
Yes, sir.
variance that was approved in 2019, the lot usage ratio was approved at 38.6, 38%.
I thought it was 40. Let me double check. Hang on.
It seems that we're starting at 40. How did we get from 38% to 40?
It was, I apologize, Mr. Walsh. The resolution references .386. I don't have an answer to your question. I can ask my client, was there any work done that increased the lot usage ratio between?
I don't think so.
It's a sizable number.
Yeah, .014. I mean, the work that was completed,
This 40.8, what we calculate from the existing condition.
Right, but it was approved back several years ago for
I-
38. So there's something that doesn't jive someplace.
I can,
A new shed, a bigger shed.
Oh, shed.
but the shed was approved, that was
Shed
the
was
subject
approved.
of our prior
But a
application.
bigger shed, maybe?
When we came in, I was the attorney of record when we came back in 2019. That shed was actually existing on site, and there was an issue with the shed being located with respect to approval, so we had to obtain variance relief in connection with the shed at that time.
So right now, it's 40.8.
Pursuant to Mr. Nasser's calculations.
All that's on here is a shed and a house, right?
Correct.
And did you add anything to the house?
We did not.
Well,
Well, since-
the family room and the paver patio in the rear, but that was the subject of the 2019 application that was approved by the board.
Right, but that was presumably reviewed and consistent with the plans that you submitted when it was done.
We would have had a final inspection after the construction was completed.
Well, maybe it's just engineer math.
Maybe it was erroneously prepared on the original application.
I don't remember off the top of my head who our engineer was back. It may have been Mr. Hender, I want to say.
It could quite simply be a surveyor discrepancy. I mean, you have two surveyors survey the same lot,
Yeah.
and the lot coverages come out different. I had run
That's
into
what I
this.
meant by engineer math. Like, it may be
Yeah.
just, they're taking the rule and just measuring stuff and say, oh.
To be fair, if you put 10 lawyers in a room, we'd give you 10 different answers
Your
as well.
testimony, though, is that you received the approval, you built consistent with the approval, and you haven't added any other structures since you did.
Yes, sir.
Construction. That's your testimony to the road. Engineer report?
I have question for you. So to follow up, under this proposal, you are proposing to increase the lot usage ratio to 43.4% with the porch addition, correct?
It would be increased, that's correct.
Okay.
And then slightly, the generator platform would slightly increase it as well. I don't know that, did you happen to carve that out?
It's 0.2%.
0.2%.
Are there any other residences on Pittsburgh that have the same streetscape with a porch extending that far? You're asking for a variance to go all the way, to go from 25 feet and eliminating 10 feet of that, to build 10 feet into that area. Are there any other properties on Pittsburgh that extend that far? And if Mrs. Farrington knows the answer as opposed to Mr. Nasir, open up to anybody
Well,
to respond.
To be honest with you, I don't know that answer off the top of my head, but I do know on Missouri that they just I think they just put two porches in that look identical to the one we're trying to get.
Are they screened-in porches?
Yeah. One of them I know is a doctor. I don't know if it's on Missouri, but isn't it Missouri? Yeah, I believe it's Missouri.
Are you considered Village Green where you are?
Yes.
Okay.
And I think the only follow-up that I would add is, we did submit a neighborhood survey. Obviously, that's limited to this block, which is limited to essentially this property, the Shamala's property, and I believe there's one other property.
So I got phone calls from everybody except the one next to me, but you know him, and he said he's fine with it. But people across the street say, oh, great, maybe we can come over and enjoy that, because you never come over or outside with our neighbors next door. They're supportive of it, and our other neighbor behind us that's literally touches our property, we're very supportive of it.
And just to follow, I think the unique nature, we recognize we're asking for a variance. We encroach approximately, give or take, 10 feet into the front yard setback. It's a little bit unique based upon how Mr. Nasser testified. This is a significantly large public right-of-way. The roadway itself is, I believe you testified, about 100 feet in width.
Yeah, the right-of-way is 100 feet, and the curb it's about 20 feet plus from the property line. Normally, standard streets is 10. So that gives us the feeling that you're not really encroaching onto, or you're imposing onto the actual right-of-way or the streets.
It's unique in the sense that if you look at the property line, it actually, the public right-of-way is a significant difference in front of where that property line ends. So, in other words, I think Mr. Nasser's testimony, I learned my lesson, I'll take my microphone with me, is if you look at the lot cover, the property line itself, this front property line actually it ends here. The curb line actually starts here. So while we are encroaching into the front yard setback, the building setback line, if you will, it's unique in the sense that there is a significant distance, which, as Mr. Nasser testifies, does mitigate the visual impacts to the neighborhood and to the and from the roadway as well.
I do, if I may, on Pittsburgh Avenue, and I don't know, it's towards the beach, maybe down towards where you live. There's a corner house there that has a screened-in porch. I don't know which street it's on the corner of, but I know they have one that protrudes a little. Because we went in their house and took pictures and thought if that's the style we liked.
You went through the trouble of preparing this neighborhood survey. You may want to look at it. It's probably going to help you out a little bit here. And it's not just for that block. So there's a pattern of existing nonconformities there that you may want to,
I know we did submit it.
I don't like to testify for the
No,
applicant.
no, I understand.
You went through the,
Purposes of expediency.
I don't have a copy.
Well, we're gonna mark that one though, because it doesn't seem to be readily apparent. So that's Exhibit A.
We did submit that, but I have no objection to marking it as
Yeah,
Exhibit
it's
A1.
just not, I don't see everybody having it now.
I think it came early and it may not have made the final package.
I think the reason why, I know exactly why we didn't resubmit it, Mr. Hurlis. We didn't resubmit it because we weren't able to utilize the lot averaging because of the number of properties on this
Right.
specific area. So while we prepared it, it really didn't justify.
Going to address the board's questions, what I'm
Yeah.
directing you.
To answer your question, there's properties, the setback is 18.2 feet of the structure, the actual house. Other properties, 19.6 feet within the blocks. So when we are proposing the screen porch to be at 15.4, it's not really a stretch because the actual structure is sitting at 18.2 feet on the left side of the property.
Mr. Bodnar, would you like to see the neighborhood survey?
May I?
Sorry about that.
So the one next to us on the left is 18.2 feet, the actual house, not the porch.
And Mr. Nasser, I'm going to hand you your microphone, but the house that is located at 18.9 feet in the setback, that's the house, not the structure, the neighboring structure,
It's
correct?
18.2 feet, yes.
And the facade, the actual wall of the main structure in this situation actually exceeds the minimum 25-foot building setback requirement, correct? And it's
This is just the porch is
the
encroaching,
porch.
yeah.
Any other questions?
Thank you.
I have a additional question. So just the way, ask you about the pavers that are in the front yard. It's kind of unique compared to the setup as far as with that paver setup compared to other Village Green properties. Is that the way it's configured and proposing to be configured? Is that part of your parking solution as far as the actual parking spaces on, for this property?
Just to keep the parking space. So we are
Here, hold on, let me get you your microphone.
Sorry. We are reconfiguring the pavers, but we are eliminating some of the pavers to stay with the coverage. So we'll have like some grass between the pavers.
Okay, but my question is, so the pavers that go across the front entryway, that's part of the,
Yes, sir.
that's parking.
Right, like
Correct.
if you look on the right side, that's how it is. On the property on next to us, that's how the parking is. So we're just doing the same thing. We're just moving the pavers closer to the street.
So as far as green space in front of the house, it's essentially, there's going to be less than there was now by way of with this proposal, there would be less, correct?
We're just adding the grass in between, so it'll be probably a little bit less, yes.
But also the building is coming out as well,
Correct.
so that's going to eliminate that.
Correct.
So I did submit photographs along with the application, which do depict the appearance from the front of the property. And I know landscaping, while Mrs. Farrington may not be able to actually go out there and plant and garden herself, landscaping is something that she takes pride in, and it's something that she's willing to incorporate, to the board's satisfaction to provide an additional buffer to this proposed front porch, so that it even further minimizes any negative impact or visual impact, if you will, to the general public or neighboring properties.
And under the proposal, would there be any, other than taking out the center strip, would there be any paver work done? Are they going to be moved in any way, or is it just the existing pavers?
The pavers in front of the addition, they have to be redone. You have to take them out and redo the whole section here.
So it's going to come further towards the
Yes.
towards the street?
I would
Is
say
that correct?
about 3 or 4 feet, yes.
Any other questions? All right, Craig, if you will.
Okay, so I'm going to summarize my August 16th, 2023 memorandum. This is a project located in the R4 Modified Medium Density Residential District. You've heard testimony from the applicants indicating this is a proposed screened front porch, as well as a proposed generator platform that's located at the rear of the structure. I'm going to roll right into the completeness review. There were waivers requested from items 26, 28, as well as 33. I supported all of those with the exception of item number 33, which is to provide a landscaping plan, and the applicant has agreed to do that, so that should be a condition of approval. So based on those recommendations, I did support deeming the application complete. To summarize the variances, so it's an existing undersized lot. The lot size requirement in the R4 district for semi-detached structures, which are structures that have a common party wall where the lot line essentially runs, and there's a mirrored structure on the other side of it, for lack of a better term. That lot size requirement is 5,000 square feet in the district, where 4,905 square foot exists and is proposed. The structures themselves create a nonconformity. The front porch has a 25-foot setback requirement. 25.4 foot exists to the existing structure. The porch will encroach and have a setback of 15.6 feet. And that lot usage ratio that I explained through the definition, the maximum permitted is 36%. The structures drive that. 40.8% is indicated on the plans as existing, and that is proposed at 43.4%. So those are the three variances that are being requested, and I'll move into my general review comments. These all should be conditions of approval, and they begin on page 4 or 5. Conform with Chapter 258, the Flood Damage Protection Code. 2 is revise the zoning table consistent with the comments in the review memo. 3, they did provide a grading and drainage plan. We did find that satisfactory. Our standard condition is, should the improvements change the stormwater runoff patterns, a grading and drainage plan should be required and approved by the zoning board engineer. Item 4 refers to the new stormwater ordinance 485, so that they have to comply with that also. 5 is the recommendation to provide landscaping in the front yard to buffer the setback encroachment. They've agreed to do that. 6 is our standard condition that we will evaluate the sidewalk, and that should be replaced to the satisfaction of the board engineer. 7 is comply with the requirements of the Cape May Shade Tree Commission, Fire Department, and Public Works Department, and the applicant has already gone through those reports and have indicated that they will comply and revise the plans to indicate compliance. 8 is our standard condition. They have to comply with all other state, county, and local approvals. 9 is informational. This project is not located in the historic district. 10 is our standard condition that they have to comply with any and all applicable affordable housing requirements. And 11 is the requirement, should the board grant approval, they have to revise the plans consistent with the conditions that the board sets and provide the requisite number of sets to the board engineer for review and approval. Happy to answer any questions the board has.
No questions?
Thank you.
The application for you as requesting
I'm sorry, we're going to open to the
No.
public?
Oh, yeah, why don't we do that? There wasn't anyone here when we started. Open that public.
Oh, sorry. Thanks, Karen. We'd like to open to the public, anyone within 200 feet? Beyond 200 feet?
Thank you.
Okay, this is a C2 variance request where I incorporate the standard that's in the engineering report on page 4 that I reviewed with you in the last application more specifically. The benefits substantially outweigh any detriments, and there's no substantial negative impact on the zone plan and zoning ordinance or the neighborhood. The variances they're seeking are 1 through 3 on page 3. Lot size, front yard setback, and lot usage ratio That's not to be confused with floor area ratio, which is a different kind of variance that is traditionally more difficult to get and requires a special vote. But on the other hand, it still is an indicator of whether a property is being overdeveloped, much like lot coverage. So you consider that in your analysis. So the motion I'd recommend being made, and again, I make it in the positive, I'd recommend being made in the positive, but that doesn't mean you have to vote that way. It just means if you say yes, you're approving it. If you say no, you're not approving it. So it'll be a motion to grant the variances 1 through 3 on page 3, subject to the conditions, the waiver of numbers 26 and 28 on page 2, subject to conditions number 33 on page 2, as well as 1 through 11 on page 5. Although that's in the motion, I suggest be in the affirmative. How you vote is up to you. And this requires a majority 4 out of 6.
Can I ask a question first?
Yes, sir.
Is there any consideration for the uniqueness of Pittsburgh Avenue versus any other street that contains twins? I seem to think that changing the front distance in a different neighborhood would seem odd. You'd have the single tooth kind of concept with that. But I tend to think that Pittsburgh, being a wider street with bicycle lanes, provides a different look of setback. Is there any consideration for that kind of uniqueness of a
Well,
neighborhood?
they put in testimony to that effect, because I think that there was a lot of testimony about the fact that sometimes when you look at the picture, you see the lot line, it's this dark line, it makes you think that's where the road is, but the road is actually much further away. So they're calling it the right-of-way. There's an area in front of that. So visually, although it's only going to be 15 feet, when you're going down the street, it's going to look further back. So, and that's what they're talking about, as being a wide street and a wide right-of-way. Am I saying that correctly?
That's accurate.
So they put in that testimony, because one thing, you do want to distinguish this from other streets, otherwise you'll have big front porches on every property. So that's a fair comment, fair, and that's part of the things you should factor in. And they put that testimony is in the record, so it's fair for you to consider that if you think that's important. Okay?
Mr. King,
Sir.
related to that, my understanding then, the testimony was, so this property is not 15 and a half feet, or the proposal is not 15 and a half feet from the curb line, it's 15 and a half feet from the property. And then there's an additional, I guess, so many feet that goes to the present.
Mr. Nasser, just to make sure the
drive.
record's clear on this, can you just review where the street is, where the curb is, where your pavers are, and
Sure.
where the porch is going to be?
Sure.
Just do that.
So if you look at this dark line, that's where the front property line is. This double line here is where the curb, basically 20-plus feet away from our property line. And this shaded area is what we're proposing for the covered porch. So from the curb line to the covered porch is 35-plus feet at this point. And from the curb line to the existing house, it's 45-plus feet.
And where the cars park, those are how far from the curb?
You're going to have, the driveway is almost 14 feet in the right-of-way, plus the additional 25 feet.
Right, so it sounds like there's going to be porch, cars, street, all bunched together, but visually, and that's what your colleague was talking about, that particular road is a very big road, so that is an important factor in their application.
And it comes across differently. If you were looking at another house in Village Green, it just wouldn't look that way. You wouldn't get a plan that way because it's different.
Would not look the same.
Right.
Just for the board's education, on most of our side streets, our local residential streets, essentially from the curb line to the sidewalk is 3 feet. And you have a 4-foot wide sidewalk. And then typically the property lines start 3 foot on the back side of the sidewalk. In this case, you have that 3, you have the 4 for the sidewalk, and it looks to me over 10 feet from the back of the sidewalk to the property line.
Actually 13 feet plus.
Yeah, so because of the wideness of this right-of-way, It's set back further than you would think.
And I think, I appreciate that being raised. I think that's something important for us, for me, certainly, to note, considering this type of application, especially when it comes up in Village Green, because it's going to come up as far as people want to build porches, people are moving closer to the street, and because some of the unique issues with Pittsburgh, it's just, the math is different. It's still, and I think what's important from the testimony here is we're still talking 20-some feet away from the street, as opposed to, this isn't 15 feet away from the street.
We run into the uniqueness of Pittsburgh pretty often in Village Green, because also fences are an issue in Pittsburgh, because they're on a big, busy street. I remember people coming in and trying to get fences, and where fences might be offensive on different roads, Pittsburgh is kind of a little different. And I do want to address one other thing, not just for this application, but others. There's testimony about this, the applicant's specific condition regarding mosquitoes and this and that. That really is not a reason to give a variance, because variances are about the property and not the people. But I will say, we have had other applications where I know the board has considered public health, safety, and welfare for screened-in porches for protection from mosquitoes generally. So even though this applicant has a particular sensitivity, according to her testimony, we have talked about screened-in porches in the context of light, air, and open space and advancing safety, because particularly down in that area, getting near the marsh over there and stuff, it's a little more so than being on the front of Beach Avenue or something. So that has come up in the past, and I remember specifically over in that area, it came up. Okay, so I've already said the motion that I'd recommend being made, but it's up to you. You can always make whatever motions you want, but the motion was to grant variances 1 through 3, subject to, with waivers 26, 28, subject conditions 33, and 1 through 11 in the engineer's report. How you vote is up to you, but the motion I recommend being made in the positive.
Anyone make a motion?
So move.
I'll second.
I'm sorry, who seconded it? Mr.
Steve.
Bodnar, thank you. So we have a motion by Mr. Ledwin, seconded by Mr. Bodnar. Mr. Ledwin?
Yes.
Mr. Walsh?
No. I feel the property's being overdeveloped.
Mr. Zexer?
Yes.
Mr. Cataldo?
Yes.
Mr. Bodnar?
No, for the same reason as stated by Mr. Walsh.
Mr. Venuto?
I happened to take my puppy for a walk all through Village Green today, and it was amazing how many different screened-in porches of multiple shapes and sizes were in existence. So with that in mind, my vote will be yes.
Thank you.
I have the vote of 4 to 2, so it passes by a majority.
Thank you very much. Have a nice evening, everyone. Thank you for your time.
Thank you, gentlemen. Mr. Messer, real quick, I just,
Okay. Our third application would be 1005 Beach Avenue LLC at 1005 Beach Avenue, Block 1095.
I think we lost our board.
We'll take a 5-minute break.
Microphones off, please.
Okay. Again, our third application, 1005 Beach Avenue LLC at 1005 Beach Avenue, Block 1095. Can you introduce yourselves, please?
Thank you, Mr. Chairman. Good evening again, everyone. Andrew Catanese on behalf of the applicant, John and Jeannie Kohler. Their LLC is 1005 Beach Avenue LLC. To my left is Mr. Kohler and Mr. Robert, sorry. And John Halbruner, again, our project planner, architect, and engineer. The subject property is a substantially oversized lot on Beach Avenue, and it's the site of two buildings that exist and are proposed to remain. The main house is currently a triplex, and then in the back, there is a garage apartment. Now, that brings the total number of units on site to 4 as it exists today, and the lot is certainly big enough for that. In fact, this lot is so big you can have a 6-unit multifamily structure on the lot and meet the density requirements. But our code prevents these properties from having these units in separate buildings. Whenever you're in separate buildings, it's a non-conforming use, and that is one of the issues we need to deal with today. The Kohlers are planning a substantial renovation of the property. The primary goal is to convert that triplex building in the front of the property into a single-family home. So they'll be reducing the total number of units on site from 4 down to 2, with that primary building becoming a single family as it was originally constructed many years ago. The zoning officer directed us to the board requiring approval in order to reduce the number of units. And separately, there are a few very small expansions of that building that are proposed. John will go over them in more detail, but the 4 expansions are, number 1, there will be a new dormer up on the roof. Number 2, there's a small rear deck or landing and stairs that'll provide access to the back of the property. Number 3, there's going to be an HVAC platform that'll be attached to the house. And number 4, there's an area of attic that will be converted, 2 areas of attic actually, that'll be converted into closet space. Total additional square footage is 102 square feet, so certainly not much. So the building is basically remaining the way it is. The other changes will be site improvements, landscaping, pavers, hardscaping, et cetera. The lot coverage will remain at 48%. That's what it is right now. Now, we believe that's conforming, but the code is a little weird on this. For a 2-family unit or anything more than that, the limit is 70%. So we proposed 48% as conforming since there are 2 units. Mr. Hurlis has suggested that because there's a single-family home on the site as the principal structure, the limit for a single-family home is 45%. So we did notice for a impervious coverage variance, not because it's increasing, it'll stay at 45, but if we apply, it'll stay at 48%, but if we change the standard down to 45%, it would trigger that variance, which is more technical than in function. So that's it. It's a couple small changes to the house, convert the house to a single, fix up the site, and with that, we will go to Mr. Halbruner. HPC did grant conceptual approval for the building, including the dormer and the little rear deck, the things I discussed. I know we've qualified Mr. Halbruner already tonight, and if he's still under oath, we'll turn it over to him. We don't plan any direct testimony from the owners, but if necessary, they could certainly answer questions.
I just need 1 second. I can't find Craig's report. I know I had it, and that's sort of how I get through these meetings is Craig's report, so.
I have an extra one, unless you wrote on it.
I'll take it. Thank you. Thank you. Sorry, I'm sure I got mixed in another application. I threw it up there. Okay, good. We're swearing someone in. Mr. Halbruner, are your witnesses testifying?
Maybe. Well, why don't we go ahead and,
I'm
yeah.
going to swear you in as well. Mr. Hurlis remains on both. Please raise your right hand. Do each of you swear or affirm to tell the truth, all truth, and nothing but the truth?
I do.
I do.
Thank you.
Thank you. Mr. Halbruner, why don't we start with existing conditions?
Sure, but as you've indicated in your opening statement, we have a oversized lot. It's 100 feet wide by 165 feet deep, 16,500 square feet. It's developed with I'm going to use the word principal building, the 3-story home that is a triplex That was the building that you see most prominently from Beach Avenue. In the back of the property, there's a two-story garage with an apartment with that, which brings the total number of units on site today at 4 units. Site improvements are limited to a stone driveway with a parking in the rear of the building. And again, I'll use the word principal building, although technically they're both principal buildings. The larger building, the triplex building, is fully bulk conforming with one exception. There's a non-conforming side yard setback on the east side where 10 feet is required. This building has 3.3 feet. It's a condition that's been there for as long as the building's been there. And nothing about this application will exasperate or increase that degree of nonconformity. The garage building itself, the garage apartment, it has several non-conforming situations with regards to your bulk ordinances. Probably first and foremost, it constitutes a second principal building. Even though it, by all appearances and almost function, it's an accessory building, it is because it's not attached to the triplex building. It's a second principal building. So we have a non-conforming lot with two principal buildings, which is really what drives us being here this evening. Being a principal building is subject to all the setbacks of a principal building rather than a relaxed standard for accessory buildings. So the rear yard setback, where 5.8 feet exists, 25 feet would be required, and a side yard setback where 10 feet would be required, 6.6 feet exist. Again, those conditions are absolutely unchanged, unaffected. We're not touching that building as any part of this application. In fact, the improvements that we're making in this application are very, very limited. It's almost like a technicality that they think we're here for. Because we're modifying a building that is a non-conforming use by virtue of being two separate buildings, arguably any modification whatsoever to this property requires a trip to the board, and here we are. As you indicated in your opening statements, Andrew, the lot's big enough to accommodate by density 6 units. Under the multifamily zoning allowances for the zone, you need 2,500 square foot per unit. When we have 16,500 square feet, the lot itself can accommodate up to 6 units, 6.6, rounded down to 6. I say that for context. We're not proposing that. We're proposing to go the other way. We have 4. We're trying to bring it down to 2. We're going to maintain the apartment in the back. We're going to take the triplex building, which is one of your old historic buildings that is in pretty serious neglect and disrepair, and we're going to convert it down to a single family, and we're going to substantially renovate it inside and out. The actual changes that are occurring, besides the conversion to a single-family home, the envelope of the building, if you will, off the back of the building, there's going to be a new dormer on the 3rd floor roof, and that's simply there to create a more functional stair for the 2nd to the 3rd floor. Like a lot of older homes, the stair to the 3rd floor is almost like a servant stair, very tight spiral, not very navigable. We're reconstructing the entire core of stairs in order to provide the requisite headroom to have a functional stair. There's a dormer that's being created. The outward appearance of the building envelope otherwise doesn't change. There's a lot of appendages that are applied to the back of the building that are coming off and reconfigured as part of the application, all of which is going to enhance the overall appearance. There's a rear, I'm going to use the word deck, it's a series of steps and landings going up to the 2nd floor. There's an HVAC platform that's back there. All that's coming down, and a more aesthetically pleasing, more functional step and landing coming off the back of the house is being constructed. A new HVAC platform is being constructed. And the only other change besides site improvements is converting some attic space on the 3rd floor within the existing envelope, taking an unfinished attic space and making 2 closets, each of them 51 square feet for a total of 102 square feet of increased closet space. So technically, we're increasing the floor area ratio by 102 square feet.
And the floor area ratio will still conform, correct?
By leaps and bounds, yes.
And in all of the changes that are proposed all meet the bulk, setback, and other requirements of the zone. In fact, the only reason we're here is because that garage apartment exists out there.
Correct. In the spirit of dressing up the project and the site, we're making a few site improvements. Again, we're going to take all those kind of haphazard appendages on the back of the building, taking them off and replacing them with a more coherent set of HVAC platform, stairs and steps to the landing. We're going to construct a new at-grade paver patio in the backyard, and we're replacing a sidewalk that extends from the building to the Beach Avenue on the east side, taking concrete out, replacing that with pavers.
Can I ask you a question? Can you just say something that's interesting to me? So forget this closet thing in the attic just for a second. This is a non-conforming use, right? The fact that you're adding an HVAC platform, is that real, that's not really expanding the non-conforming use. So in what way are you expanding non-conforming use? These closets sound like maybe that's an expansion. But other than that, what are you expanding the non-conforming use?
Mr. King, we were advised that by the zoning office that the property owners could not convert the building from 3 units to 1 with no external changes to the building.
That part
So-
I get. I
And
get
then the
that.
oh, sorry.
You're going from one not permitted use to another not permitted use. I do think you need a variance, but I'm focused on the expansion of a non-conforming use. The fact that you change some part of the structure, that doesn't necessarily expand the use.
Well-
That may expand the structure, but aside from the closets, are you, what living
It's-
space are you
The,
increasing?
the 4 items that we identified as an expansion of the structure housing the nonconforming use is the dormer,
Okay.
the interior closet expansion into the attic, the HVAC platform, and that rear deck and stair. It's the only 4 things we can identify. That's it.
So it's in my opinion, adding an HVAC unit doesn't expand a non-conforming use. I'm not clear about these outside stairs, if that's expanding non-conforming use. But the dormer and these closets are the expansion of the non-conforming use. The rest are, they may be expanding a structure, but it's not a non-conforming structure. So it's really just the dormers and the closet, I think, are adding living space to a non-conforming use.
Fair enough?
And the change from one non-conforming use to another.
That's why you need a use variance, but you're not expanding.
But you're-
non-conforming use. You would need that if you did nothing to the building, you would need a variance. Because the use you're doing is a single-family residence with a unit in the back, 2 principal uses, you need a variance.
The apartment over the garage is what's the non-conforming.
Yeah, that's it.
Right.
That's it. Whether it's 3 units, multiple dwelling, or whether it's a single-family dwelling, that part is permitted. The second use, the apartment over the garage, is what is the nonconformity.
And
Right.
if you didn't touch the building at all, you would need that variance.
Yeah, we're not touching, as Mr. Halbrunner indicated, we're not touching the rear building at all.
Right.
All right, but then, so your variances are, you need a use variance for 2 principal lots, and then you need a variance for.
2 principal
two
uses.
principal uses. And then you need a variance, where's the list? You need a variance for, you're expanding a non-conforming use, but I just wanted to be clear that that expansion is only, do you even need that? You're getting a new variance.
Mr. King, I'm respectfully a little confused as to why we needed to be
You
here in the
absolutely need to
first
be-
place.
I don't mean, there's no confusion in my mind on that, but you're basically getting a new use variance for the thing that you're building. So you're not expanding a non-conforming use, you're basically getting a new use variance for
To reduce from 3 units to 1.
3 units to 1, and that new use has a dormer and a closet in it.
That is bulk conforming.
Okay.
That is bulk conforming.
I think this is subject to the relaxed D2 standard because it's existing. The 2 uses are existing. I don't think we're creating the nonconformity for a
I
D1.
guess so. All right, I'll go with that.
We're getting hyper-technical.
It
It's a
is.
simple
Well, it's a
application,
standard.
so I
wanna
don't,
make sure this all affects the standard. Expanding a non-conforming use is one standard, 2 principal uses on a lot is a different standard, but I think that you are, I think it is a regular D variance for 2 principal uses on a lot, but I think you get a lot of credit for it already existing on the property, and that it is a kind of a less intense.
The intensification of the use, I think.
Yeah.
So I do think I'm going to instruct my board, though, that it's a D variance for 2 principal uses on a lot. I don't think it's an expansion of a non-conforming use. I think It's as if you had, I don't know, one not permitted use, and then you're putting another not permitted use there. But you are getting like a Burbridge kind of analysis where you've demonstrated that it can handle it already. So I do think you get the credit. It's not, okay, we're doing lawyer talk. I'm gonna break it down to not lawyer talk, okay? But I gotta get the standard in there, because this is important for a lot of technical reasons. Okay, so when someone has a use that's not permitted on a lot, and they are expanding a non-conforming use, there's a case out there that says that that's not like a regular D variance, because they've already demonstrated that use is performing on that property, they're expanding it. So you need a variance, and it's a D variance, but it's kind of a lesser D variance, okay? In this instance, this is a different use. It's not a quadplex, it's a single-family residence with a second principal use on it. But in my opinion, it is very much like an expansion of non-conforming use, in the sense that you are giving them, it's a reduction of a non-conforming use. So you need to give them credit for the fact that this already exists on site. That you shouldn't treat it like someone is just coming in with a lot that should be a single-family residence, and they're saying, I want to put 2 residents on this. It'd be unfair to treat them that way. But it's also not a classic expansion of a non-conforming use where, it's a 7-Eleven on a lot, and they're going to add to it a bit. And 7-Elevens aren't permitted on that lot. So it's not really that, okay? So I know this is a complicated thing, but I just want you all to, I'm going to make them get a D variance for 2 principal uses on a lot, because it's a single-family residence and a unit in the back, which was not what they had before. But I really need you guys to give them a lot of credit for having it there already, okay? That's the best instruction I think I can give, and I think that's fair, because it's not, okay? You got that?
So before they turned it to a single-family home, it was similar to like that application we had, months ago, Ohana, on Beach Drive, where, the parking underneath, they had that kind of the carriage house garage units in the back.
Yeah.
It was similar to,
Yes, I know a little about that one.
It would be, except on that, oh yeah, they did make that in the single family in the front, didn't they?
No.
No, they didn't. I was gonna say, except the fact that this is gonna be a
structures.
single family.
2 structures, but I think they're converting them into,
The fact that it was 2 structures
Condos.
drove the D variance.
Right. And that standard, the Burbridge versus Mine Hill standard that Mr. King just spoke to, is one that I had written down. I get what you're saying. This is, if you instruct on a D1, but we think about it, that Burbridge versus Mine Hill Township standard says where you have an existing non-conforming use, number one, the property owner enjoys a benefit that a person with a blank slate piece of lot, blank slate lot doesn't have. The use that is there is existing, it's permitted, and you're not starting with a blank slate. And the Burbridge case speaks specifically to that and says that's an advantage that someone with an existing non-conforming use has over someone with a vacant lot. It's a totally different analysis, because the board should take the opportunity to harmonize the lot and the use with the environment and reduce the extent of the nonconformity, right? And in this case, we're sort of bringing down all that density and making these things better. So we think that that makes sense here. So I think that that type of an analysis makes sense.
Yeah,
Again,
so I'm gonna do a regular D variance, but I'm just giving that instruction, that this is not like someone came in to put a restaurant in a residential zone, and then they gotta show that the site is specifically,
No site suitability
It's-
test.
you know,
Right.
It's a very complex thing, so I'm gonna do a D1, but it's a modified D. Okay, Craig, do you have any issue with that? Do you agree with that analysis?
No, I agree.
It's really just.
It gets weirder too with the lot coverage thing too, and I'll explain that later.
Okay, good, I'm sorry to slow everybody down, I know this is hyper-technical, but it can be the difference between winning and losing, or getting appealed and not appealed, so we're gonna make that right. Go ahead.
Okay, I think the only thing I haven't yet described about what the proposed improvements are is the significant landscaping improvements that we're proposing. We're planting over 200 no trees, shrubs, and plants as part of a very extensive landscaping program, both in the front and the rear of the building. I think that should characterize all the proposed site changes. Now notably, we're not doing anything to change existing grading patterns or flow. So there is no grading plan or stormwater management plan that you might normally be accustomed to. The existing flow patterns are remaining, we're not changing it. I know Mr. Hurls is probably going to bring that up in his report, but I'd like to make clear that we're not changing those flow patterns, we're not increasing the flow. Coverage is staying the same.
John, you talked about this property being sort of underdeveloped, but, and much less intense development that we're going to be preserving and keeping in place as we move forward. Front yard setback, what's required and what's existing and remaining?
The required front yard setback is 20 feet. We are 42.6 feet to the triplex building, proposed to be single, and we're 133 feet to the garage apartment.
The lot width is double what's required, right?
Correct. What the lot width is conforming at 100 feet
Oh, I'm sorry.
for multifamily.
Got it, for multifamily.
Yes.
Got it. And the floor area ratio you mentioned generally was well below permitted, but just to give an idea of how, again, underdeveloped this lot is, what's permitted FAR in this zone and what's proposed?
Bear with me, go back to the architectural plans by Mr. McAfee. Oh, thank you. Where 0.65 or 65% would be the permitted floor area ratio, we're at 0.34%. We are effectively half of what the floor area ratio would otherwise be allowed for the zone. And I'd like to use the word de-intensification of use when we're talking about the conversion from a 3-unit building now to a 1-unit building. To almost everyone in our profession and in the industry, more density is not good, less density is good. So we're taking a high-density 4-unit and taking it down to a much lower density 2-unit. That is a de-intensification of the use, albeit a change in the use.
Now, I mentioned about the impervious coverage. What are the impervious coverage limits that apply to the various different uses in the zone? And if you give the board just a little overview on what we're talking about here.
Sure. This zone actually allows many different forms of residential buildings. At the most simple level, a single-family home, one building, one home. That has a maximum allowable lot coverage of 45%. Every other use, be it a duplex, multifamily, townhouses, and all the other permitted residential uses, are allowed up to a 70% lot coverage. We presented the application being 2 units on the lot as not being a single family, and hence the applicable standard is 70%. So our application indicated 70% is the allowable lot coverage. The existing lot coverage is 48%, and we are proposing to maintain that. As Andrew mentioned in his opening statement, if you take the position that this is a single-family home, then the maximum allowable would be 45%, and us maintaining the existing 48% would be maintaining a 3% over what's allowed.
And on the whole, do you think that the 48% proposed in connection with all the other improvements made to the site presents a better zoning alternative to what's there existing today?
Absolutely.
Even if that variance exists?
Yeah, the de-intensification of the use by itself is certainly worth more than 3% lot coverage.
Thank you. All right, now, we talked about the standard of review, but no matter how we come at it, and certainly with a relaxed standard, we need to show under any D-variance that purposes of zoning are advanced by the application. So what purposes of the municipal land use law are advanced by the changes to the site?
I believe there are 5 specific purposes of the municipal land use law that this application advances. I'll refer to them by subparagraph within the statute. Subparagraph A, which is to promote the public health, safety, and welfare, and we're promoting that by a substantial renovation, rejuvenation, and reinvestment of an aging home, restoring it to its original grandeur. Subparagraph B, to promote safety from fire, flood, panic, and other natural man-made disasters. We're upgrading all the mechanical systems. There are couple miles of knob and tube wiring within the building that are being removed as part of the renovation. Subparagraph E, to establish appropriate population densities. Again, we're reducing the density of this building by half, or this property by half, going from 4 to 2. Subparagraph I, to promote a desirable visual environment. Again, if you look at the project in aggregate between the renovation of the building and the extensive landscaping we're proposing, there will be an immeasurable increase to the streetscape aesthetics along Beach Avenue. And lastly, subparagraph J, to promote conservation of historic sites and districts. This is certainly a historic gem that's been, I won't say neglected, but certainly ignored for a while, and we're rejuvenating it and consistent with the design standards of HPC.
John, this is a contributing structure, correct?
It is.
We also applied under the Flexible C standard, which requires an analysis of whether the application advances the purposes of zoning, whether the benefits substantially outweigh the detriment. Did the purposes of zoning that you just testified to for the D variance also support the grant of variance relief under the broader Flexible C standard?
Absolutely. If you look at the positive effects, each of those purposes I just described under the D variance apply to the C variance. They're all positive effects. And in that balancing act of the positives versus the negatives, what negative could possibly shake out of this application? We're de-intensifying the use, we're beautifying the building. There is no negative. And the variances that we're seeking, I think, are at a very hyper-technical level.
And finally, in order to grant any variance, the board needs to be satisfied that the relief can be granted without substantially impairing the intent and purpose of the zone plan or zoning ordinance. Can that be done?
Absolutely. Again, the intent of the ordinance is there's no way that de-intensifying this use is going to be contrary to the intent of the ordinance.
Any questions for Mr. Halbrunner?
Question?
Can you just say about any impact on the neighbors?
What impact on the neighbors could there be for the de-intensification of these other than the beneficial impact? Less traffic, less number of units, less noise, less everything.
Okay. No questions? Craig?
Okay, I'm summarizing my June 6, 2023 review memo. This is a project located in the RS Residential Seasonal District. Heard testimony from the applicants indicating that they are proposing to convert a 3-unit multiple dwelling structure with an apartment over the detached garage to a single-family dwelling with the apartment over the detached garage. So that's the change of use. Roll into the completeness review on page 2 of 6. Item 2, I supported a waiver from. Item 5, I recommended some additional building height dimensions be provided on the plan to satisfactorily address that the dormers or anything are not exceeding the permitted use. That should be a condition of approval. 19, I supported a waiver request. Item 20, I asked for some additional information be provided on the plan. That should be a condition of approval. Item 23, 26, and 28, I all supported waivers from and therefore recommended deeming the application complete. There is a typo in my zoning schedule on page 3 of 6. I don't want to give anyone the impression that the use is permitted. It is a new single-family dwelling plus the garage apartment, which is an existing nonconforming use, and it is proposed to remain, so therefore that is a nonconforming status. I did write it up that way on the following subsequent page, but I just wanted to make sure that that typo was addressed. So other than the use variance that we've already discussed, there is the one additional lot coverage variance. Mr. Halbrunner touched on it. In the RS district, we have a menu of lot coverages. So right now, it's a multiple dwelling. That permits 70% lot coverage. So the 48% that exists now is substantially underneath what is permitted. Converting that to a single-family dwelling, which in my opinion, that's the principal use on the site, is the single-family dwelling. The 8-bedroom single-family dwelling is the principal use. The apartment over the garage is the lesser use in planning terms, but so that's why I use those standards for a single-family dwelling. Now, that conversion goes from 70% lot coverage allowance to 45% lot coverage allowance. It's weird in our ordinance that it does that, and it's quite a departure. So we've run into this case whenever there's conversions from a higher use to a lesser use, and it triggers these lot coverage variances, but the strict reading of the ordinance says it's supposed to be 45% for single-family dwelling. They're at 48, they're not increasing it, remains at 48, so it is what it is. So those are the two variances I believe you need to grant. I'll roll into the general review comments on page 5 of 6. One I've already talked about, just provide some additional building height information. That should be a condition of approval, and comply with all of the other elevation requirements and flood damage protection requirements that are indicated in item number 2. Item 3, they did a comparison zoning table on their plans, and I just asked them to take that off. Just it ends up being confusing after the application is approved. So it's fine for testimony and comparison, but in reality, there's no two-family detached use being permitted here, so, or proposed here, so I asked them to remove that from the plan. Item 4, the grading information has not been provided, so in this case, I have not witnessed any issues there, but it's our standard condition that if the improvements change stormwater runoff patterns, then a grading and drainage plan should be required and approved by the zoning board engineer. 5 is our standard condition to replace sidewalk adjacent to the subject site. 6 is, all of these are standard conditions. 6 is to provide the inspection escrow and tie the certificate of occupancy issuance to the acceptance of the improvements. 7 is to comply with the requirements of the Cape May Shade Tree Commission, Fire Department, Environmental Commission, and Public Works Department. Can you comply with those, or is there any issues?
Well, Fire and Public Works, I think, had no comment. Shade Tree made a couple recommendations. We revised the plans to save the holly bush as they proposed. We are proposing to eliminate the Japanese black pine on site and replace those per, and I think John testified to, I forget the number of new
We're
plantings.
over 200 plants. And for clarification, the Shade Tree report referenced pitch pines, which we have verified, Bob says verified, they're not pitch pines, they're Japanese black pines.
Okay, so they actually refer to them as scrub pines?
Scrub pines, yes.
So you're saying, what are they?
They're Japanese black pines. And we are proposing, they're indigenous, they're not indigenous, they're invasive. We're
So
proposing.
you're proposing to remove them?
Correct.
I looked at the landscaping plan, it's substantial, I don't have any issues with it, but whenever, we typically take these as recommendations, so whenever we deviate from the Shade Tree Commission's recommendations, we just have to discuss it and note it as a condition of approval. So I don't see any issue with it, but the board is happy. they
I
can
would
discuss
encourage
it.
the board to look at the landscaping plan on sheet 2. You'll see that, again, there's over 200 shrubs, trees, and plants. The loss of some relatively ugly Japanese black pines in favor of the very robust landscaping plan, I think is a very good trade-off.
Does anybody have any objection to the proposal that the landscaping plan will be utilized in lieu of the shade trees concerns regarding the scrub pines? Everybody's okay with that?
Is it possible to get adjudication of whether it's a black Japanese or a indigenous?
We submitted it.
Arborist make the determination?
We did submit a detailed report
Okay.
with our submission. Mr. Hal Bruner's associate Faith Midgarden went out. There's probably a 6-page report in your package where she identified in detail that these really are Japanese black pine, explained why, and that, and again, they're not indigenous.
Okay.
We're not cutting down a 300-year-old maple here.
We are not cutting down 300-year-old maple. No way.
So it's going to read, it says the applicant does not want to remove the Japanese black pine, which the shade tree calls scrub pine. The landscaping plan is substantial and that is acceptable to the board.
Did you say the applicant does not want to remove?
What did I say? The applicant does not want to remove the Japanese black pine.
Wants to
Oh,
remove.
oh, yeah, yeah. Oh, yeah, yeah, yeah. I meant to, actually, what I meant to say was preserve. The word remove should be preserved.
Got it.
Landscape plan is substantial and that is acceptable to the board. That's what this is going to say.
Thank you.
Okay.
Unless someone has an issue, then I won't.
I'm going to continue. Number 8, any approval is conditioned on compliance with all other state, county, and local approvals. 9, this project is located in the historic district, so we will need evidence of final HPC approval. 10, you're required to comply with any and all applicable affordable housing requirements at the time of approval, issuance of building permits, or certificate of occupancy. And number 11, finally, is providing the revised plans consistent with any approval that the board grants with any conditions, and submit those requisite number of compliance plans to the board engineer for review and approval. That's a summary of my review, and I'm happy to answer any questions.
No questions? Okay, at this time, we'd like to open up to the public within 200 feet.
Sir, I'm going to ask you to please raise your right hand. I'm going to swear you in, and then I'm going to ask you to say your name, spell it, and give your address, okay? So do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Okay. What is your name?
My name is Frank Fisk, F-I-S-K-E.
What's your address, sir?
1012 Stockton Avenue, which is the house right at the rear of the 10005 Beach Drive house. So we abut. Okay,
Is the microphone on, Green? Thank you.
Oh, it's green now, sorry.
Perfect, thank you.
Okay, Frank Fisk, F-I-S-K-E, 1012 Stockton Avenue.
Go ahead, sir.
Okay, we are concerned that the proposed 6-foot wooden fence at the rear of the property will adversely affect our property at 1012 Stockton Avenue, which is situated directly behind 1005 Beach Drive. We believe that the proposed fence will violate the General Municipal Goals 1.5 of the Master Reexamination Plan from March of 2019. Specifically, we refer to page 17, A, B, C, G, and J. The proposed fence will cause our property to lose airflow and light, and would rise to the level of 30 inches from the roof line of our apartment at the rear of the property. Currently, a 5-foot privet hedge exists exactly where the proposed fence would be erected. This hedge allows some light and continuous airflow. Being situated 1 block from the beach, we enjoy the natural breezes from the sea and wish that to continue. We are also concerned that a fence would pose a risk to our property in case of flooding or extreme weather, when dislodged fences can become projectiles. Our request is that the current hedge be allowed to stay instead of the proposed fence.
The fence isn't there now?
No, it is not.
Why a fence and not a hedge?
The owners would like a fence. It's fully conforming. It closes in the yard, keeps in dogs. There's no variance sought for the fence. It's pretty routine, frankly. A 6-foot fence around the rear of the property.
Yeah.
Can you just explain, I'm just out of my own curiosity, can you explain, you said about the fence is higher than the roof line of your apartment or something?
At the very, very back of the property, 1 foot away from the current hedge, is a garage apartment that I stay in 2 months of the year. The roof line comes down to a point where a 6-foot hedge would be 2.5 feet from it. 2.5 foot fence would be 2.5 feet from it. You're talking about blocking the light out of the 2 windows that are there, which is the only light in the place in the first floor. So, I mean, you know, it's affecting us adversely, and the
Yeah, I mean,
number 17,
you do have a non-conforming structure in the
We-
rear already, so.
Yeah, and we spoke with Mr. Fisk prior to the meeting, and Mr. Kohler did offer for the width of that adjacent residence, it's approximately 20 feet by Mr. Halbrunner's calculation, that Mr. Kohler would be willing to drop the fence down to 4 feet for that section.
well, the entire fence, even where it's not next to the garage apartment, will cut down the airflow to our actual house, which is some 40 feet back, which has a back fence, a back porch, and which we sit there and we just enjoy it all the time, and I think that will lessen our enjoyment.
Is, okay. This rear structure is also in your sight line? The structure that's there, how close is that to you?
The structure, the main house, I call it, is 40 or 50 feet away.
How about, isn't there a house in the rear? Isn't there a building?
The house in the rear is a garage apartment, which is 1 foot away.
Right, and that is near you?
It,
Can you tell which lot you are? There's two lots to the rear of the structure.
Lot 2.
You're lot 2?
yeah, we're lot 2, 1095, lot 2.
Mr. Fisk, can I show you the plan, and this way you can specify? We're looking at the site plan and the house that's marked adjacent residence. That's your home?
That's a garage apartment, and this is the fence. We're talking, the porch. This is up here. It's not even on the map where we are, the actual point. But
The testimony is that this is going to impair your building that's far enough away from the Kohler's property that you can't see it on this plan?
can't see it on that plan, but you sure can.
Are you willing to make 4 feet?
The Kohlers have consented. Right here, there is the adjacent residence. Apparently, there are, I don't want to speak for Mr. Fisk. I don't want to take over, but to
Your
get to
stuff,
the bottom.
what you say isn't testimony anyway, so go ahead.
Exactly. Mr. Fisk, we understand that you have 2 residences on your property. There's a garage apartment in the back, and then a principal home up towards the street, right?
That's correct.
And we see one of them, the garage apartment, it says ADJ for adjacent residence.
Okay.
Does that sound right?
I've never called it that, but you did. That's fine.
Yeah, I'm just making sure when the board looks at their plan, they know what we're talking about.
Gotcha.
So board members, as we look at that plan and we see the ADJ residence. Very small, but. The Kohlers would agree to drop the fence down to 4 feet as it runs just along the width of that adjacent residence. It's our understanding that there are some windows on the back of that adjacent residence. Dropping the fence to 4 feet would prevent them from being blocked in by a 6-foot fence, but we're not willing to amend the application to continue that 4 foot as you get into the open yard to the right of that. Right. So we're happy to amend the application to call for a 4-foot fence just along the width of the principal structure of the ADJ residence. Did I make that clear?
Okay.
What is next to that? It's marked, is that a different neighbor's garage?
Off to the
Correct, yeah.
left?
That's another neighbor's garage?
I believe so, right, John?
Yes, it's another neighbor's garage. That one connects with the street further to our west, which is...
There's 3 garages all next to each other, to be honest with you.
I can't remember what street, Queen Street.
The situation is that we're not going to accept a fence of any kind. We want the hedge to stay.
I understand, but, okay. There's an ordinance that lets you put up a fence, though, so I mean, we're trying to, find something everyone can live with, but I'll have the board vote on the fence separately if you want, but the
yeah.
applicant,
Yeah.
if you bring the fence to a vote, the applicant's gonna want them to vote on a 6-foot fence. If you accept the 4-foot accommodation, then we're not gonna vote it separately, they're gonna alter their application, and you're gonna get a 4-foot fence. So what would you like me to have the board vote on? And I think your bride is trying to get your attention as well.
Well, I would like to speak as well.
Oh, absolutely.
All right. You got to raise your hand.
My name is Brian Fisk.
Can you spell your first name?
It's Brienne. Fisk, Fiske.
I need that first name spelling again. I
It's
messed it up.
okay.
Sorry.
B as in boy, Rienne.
Okay. Oh, jeez. My
It'll
son
change
corrected me
it.
to Brenner.
It's okay, it'll autocorrect
It's
regularly.
like Brienne, but Brian.
Yeah.
Fisk, go ahead.
Hold on, will you swear the witness?
Yes, I'll swear in. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, and you're at the same address, 1012 Stockton?
I am 1012 Stockton, correct.
ahead.
So per the map that you all are looking at, it does not show our main residence, but it's, how many feet? From the garage
It
apartment.
shows your the rear unit.
It shows only the rear unit, which was originally just a garage and then turned into an apartment. As my husband stated, we lived there 2 months of the year. The main house is also receives the air, light, and flow, et cetera, from the fact that there is no blocking from the south winds. A 6-foot fence, which would go across the entire back of our property, would then block all light and air, will block all airflow from the east, the south, and the west, which would affect our entire property, both front and house and back small apartment. A 6-foot fence will completely darken the garage apartment that we currently live in. We would then have to have artificial light on at any time of the day in that apartment. Now, we live 1 block from the beach, and we certainly would never wish to have that kind of thing happen. That will also mean that we'll have to figure out a way to air condition that first floor. The building is very old. It's not able to be air conditioned in the regular ways anymore. So, and as far as the 4-foot fence, because our building is on the ground, the 4-foot fence would still be above the windows.
Ms. Fisk, I don't mean to throw some law at you, but.
Yeah.
But they could have probably gotten a permit and put up this fence.
Yes, I
Never
understand.
come to this board.
I understand that.
So it's, it's just one of those things where they, even if they weren't here, they could have gotten that permit and put up that fence.
I understand.
You know,
We had hoped to have this
Try to
conversation.
help accommodate you, but at the same time, it's a fence.
Right.
Even if we denied it, I'm not sure they couldn't go put the fence up like in a month from now with a building permit. So I'm just trying to.
Right.
I'm trying to get you this.
And I understand that. My concern as well is per the municipal board mission statement, I do know that, you are, one of the statements is to provide, this is with the reexamination that was done in 2019. You are considering to encourage municipal action to guide appropriate use of development. Now, development this will affect its development on their property, but it will affect ours. And in that statement, it says, in a manner which will promote the public health, safety, morals, and general welfare. So this affects our general welfare. To secure safety from fire, flood, panic, and other natural and man-made disasters. As my husband said, if there were to be a projectile from the fence in a bad storm, our property has the possibility of a man-made disaster. Another line, number C, is to provide adequate light, air, and open space. That is now going to take that completely away. And then the other thing is that you are to promote the conservation of historic sites and open space. You are now closing up space, removing open space, energy resources, and variable natural resources. Well, we will now have to use extra energy to light and air condition our property in the summertime when we are there. Otherwise, will not be possible. And we will also it will take away the natural resources of the airflow from the sea. And so therefore I consider that improper use. Now, I understand that they can do what they want, but I just was hoping that maybe that the board could consider what the effect of, I mean, we are a long time, I've been to Cape May since I was born, and I understand that progress is going to happen. But, you know, occasionally in the effort of neighbors and friendliness, I would just hope that you would maybe possibly grant the ability to either keep the hedge or come up with some other option. As I said, the way our building is situated and the height of it, 6 foot is horrible, 4 foot is still going to block the light. My gardens, of course, which I care about, won't get the airflow or the light either. I will be able to sit at the kitchen table of the garage apartment and reach out and touch that fence. We are the trustees of our property, and it is our job to try to maintain and take care of this building as per was planned. As the trustee, we were made trustees. And the final thing is that the discussion of less noise in that property as it goes from a three-unit dwelling to one, that is not going to. As you know, these large houses are rented to families that bring in multiple generations. So I'm sure there will be quite a lot of noise and people, as with many of the houses that are very, very big. So I'm happy to have those people come and enjoy themselves and have a grand old time. But I also I feel lucky to own the house, and I would hope that you might consider our plea to keep a beautiful structure that is open from the sea. They could still plant all of their beautiful shrubbery. It looks gorgeous. But the 6-foot fence is not a very neighborly thing.
Would fence be more acceptable to you?
Pardon me?
Well, there's fences and there's fences. There's opaque and then there's opaque.
Well, yeah, this is board on board, so that is really going to be solid.
How high is, I'm sorry,
I just want to try to make it.
how high is the hedge now?
The
Privet, you said?
5 foot.
And whose hedge is it? Is it,
It is their hedge.
and did they maintain it?
We maintained it for his parents while they were alive, when they got elderly, because it was too hard for them to do. This summer, when they took over the house, they maintained it. Now, in return for us helping with the hedge, they granted us the ability to walk through their backyard and to the beach. Once they bought the property, they asked that we stop that process, and we did. We have absolutely adhered to their request. So it's just that, unfortunately, the way the buildings are located and where the fence will be, it is right in our face, and it does take away a tremendous amount from our property. And as I say, I'm asking.
As far as the other question, was the house originally a single-family house back in the day? Was it built as a single-family house?
The subject property?
Right.
Yes.
Yeah, it started as a single-family house?
Yes.
Was converted to 3 families, and now it's back to...
Yes. I don't know when the hedge was planted. It was there when my family purchased the property. And the previous owners that we have been friends with, the hedge was always there.
All right, so we're back at the point place at the beginning. I mean, I have to eventually put something up for a vote, and it's my job to make sure we vote on things that make sense. So either you can allow them to amend their application to put the 4-foot.
Well, now this is the way it's going to look. 6 feet, down, over, up, 6 feet. Now, do you think that's very aesthetic looking from Beach Drive?
Oh, okay, then the board's obligation is to vote on the application before it.
I understand.
That's the only thing that I can get them to vote on.
Okay.
So that they're going to vote on the 6-foot fence, the application that's before them, and then they're going to vote. Unless you accept an amendment to their application, then I can amend the application and have them vote on that. I can have them vote separately on the fence aspect, but I really don't know how to do that. I don't know how to have the board vote on a legal fence.
Yeah, I understand.
Separate from the application, so it's.
Could a fence be built where it's staggered, so there's airflow through it?
It's-
Board on board, but, you know, it's like each board, one board's on one side, one board's on this
That's how it's
side.
proposed. There's a
Proposed,
fence
because air will
detail
get
that
through
shows board on board with, that would permit some level
Yeah.
of airflow.
The shadow box.
Yeah.
Yeah.
Yeah, so that's.
Well, there's
exactly
about this
what's in the
much room
fence.
between board on board. That's not much airflow.
I'm trying.
I appreciate it. I really appreciate it. I mean, a picket fence, something that would be, I mean, I've seen them around town. They could still have the privacy with their landscaping, you know? I mean, they're really sticking up a wall between us and the ocean. And I understand I don't have rights to the ocean, but I thought we were all trying to be working together as neighbors and in the best interest of Cape May.
Once the witness is done, I'm happy to respond.
You get to question her,
The,
but, I mean,
I have no questions for the witness.
okay, thank you.
Thank you. May I submit this letter, please, to, I was told I could, for the record,
Who told you? No, who's the letter from?
us, regarding the fence and our grievances against
Read
it.
into the record?
Pardon me?
Did someone read that?
My husband read it at the beginning.
Okay, well, then that's fine, then it's in the record, we record everything.
Okay, well, I was told that I should submit it so that it could be in the file.
Okay, we'll mark it, go ahead. It's exactly what was read, correct?
Correct.
Okay, so if.
And signed by us.
Letter, you can question that.
Just note the objection for the record, but we understand it'll come in.
Okay, go ahead.
So I do give, who do I give this to?
Put it right here, we'll make it 01, okay? And you're representing this is exactly what he read, correct? Oh, yes. Because this gentleman can't cross-examine a letter, he can only cross-examine a person, but if you're saying that's what he
No,
said.
that's exactly what my husband stood up here and read.
Who are all these people?
That's just my husband and I, our names signed and then printed.
Okay, there's a T, Franklin.
His name is,
Frank-
name is
yeah,
Thomas Franklin, but he goes by Frank.
Okay, good, thank you. I was making sure I wasn't getting a letter from somebody else, I'm not allowed to.
No, it's fine.
All right, I'm marking it 01, this is the original, you have a copy of this somewhere?
Yes.
Okay.
Okay, if you're
Thank you.
finished, then we don't have anyone beyond 200 feet, so Rich, throw it to you.
The applicant wants us to vote with the fence as proposed?
Let me, if I could address the comments that we've heard, because I think the two things came through there. There was a conversation about the Fisks previously having access across the property, and that the Kohlers have asked them to stop crossing their property to go to the beach. And the objection to any type of offense seems more consistent with trying to retain what was once crossing their property than it is about open space, light, and air. Notwithstanding that, the Kohlers are not excited about modifying the fence at all. And what they really would like is precisely what you see is the fence detail in the sheet, board on board, shadow box, allows air through, 6 feet, totally conforming to the code, and certainly commonplace throughout the city. If this is of grave concern to the board, then the Kohlers would be okay with dropping it down to 4 feet, just along the width of the principal building of that adjacent residence that you see there. But candidly, our position is we agree with Mrs. Fisk. That would look pretty silly. So if the board imposes that as a condition, you'll see no appeal from the applicants, but we'd ask for a 6-foot fence.
Another suggestion, could you lower it 4 foot to the end of the fence? Because the rest of that fence goes behind your garage, right? You won't see that.
But
And
that won't impact the Fisks. Remember, there's a
it will
property
look-
line.
I'm just looking for general aesthetics. It'll be a smaller, it'll be 4 foot and then up to 6 foot. And I'm sure that some of it will benefit them if it's a little lower, a little bit to the side.
If the board imposes it as a condition of approval, they'll comply. But again, we think this is pretty routine stuff.
well, I don't want to step in it. It's, well, whatever the board wants to do is fine with me. Somebody tell me what you want to do. I mean, they're seeking it, they do have that structure that's in the back, right, that's within the setback, right? They need a variance for that real structure, right?
Mr. King, just real quickly, and I apologize, have we closed public session?
Yeah, we're just talking amongst ourselves.
Okay, thank you, I'm sorry.
I'm taking that as your closing statement.
Yeah, I think the rest of this really speaks for itself. It's pretty straightforward. We'll follow your lead on the fence, and perhaps it's appropriate at some point to poll the board.
Is there a, don't they need a rear setback variance for that rear?
They're not doing anything to it.
But it's still there, right? I mean, there's a building in the setback. There's a non-conforming structure in the rear of the home. It's existing, but there's a, right? I mean, it's
It's
too close to the rear lot line, isn't it?
in a site plan application, perhaps, where you gather everything, I would have listed it, but because it's not, this isn't site plan, I didn't.
It's an existing non-conforming structure in the rear setback.
Right, which is why, but I didn't identify it because it's not a site plan application. That's where
Okay,
the
so-
distinction is.
Well,
May we
They're
pull
not
the?
changing the use, and they're not making any improvements to it, so therefore, it's existing non-conforming, and that's how I treated it.
No, I'm not, there's nothing wrong with that. What I'm saying is, there's already one visual and air obstruction in the rear of the home, in the rear of the property, that is not compliant with the setback, whether existing or not. So,
They could plant high evergreens that are 10 foot tall in the back. I
They
mean,
could.
And that's
they seem to be
permitted.
okay with the hedge, I don't know. I don't know.
The
All right,
ordinance,
we're gonna vote.
allows 6-foot-high fences rearward of the front of the building. So that's.
Let's vote on the application that's been submitted. If everybody, unless someone wants to vote on the fence separately, we're going to vote on the application as submitted.
It will be a 6-foot fence or 4-foot fence?
You're voting on the application as
So
submitted.
it'll be 6 foot.
Unless someone gives me a signal that they are going to vote no because of the fence, and I'll separate it, but it sounds to me like we're voting on the application. Anybody else? Any other thoughts? All right, the motion that I'd recommend being made and how you vote is up to you. I should go through a little bit on the standards on this because it got complicated for a bit. All right, so they are seeking a use variance for two principal uses on the site, but this was formerly, or as at present, 4 units on one lot, and they are reducing that to a single-family residence with another unit in the back. That is I mean, sometimes the way they function in reality, sometimes a really big house is as bad as 3 units, but in a zoning sense, it's 4 units to 2 units. That is less density by the way we measure these things in zoning. So that is a reduction in the density of the lot, and it is an existing nonconformity. So although you're voting on a use variance, a D variance, for which they need 5 out of 6 votes to pass, they need 5 votes. So as you vote, remember, your vote really, really counts. Because if 2 people vote no, this does not pass, that's okay. I'm just telling you that, I'm just letting you know that that's the vote, so no one's surprised. And it's a use variance, so you need to find that there are special reasons. Among those special reasons, in my opinion, is that it's already existing as a 4-unit going down to 2. And to me, that is a significant purpose of zoning, reducing the intensity of the lot. And they deserve some credit for it already being there. I mentioned a case called Burbridge, which means nothing to you, but what that kind of says is when a use is already existing and they're changing that use, they kind of get some credit. It's not like they're starting from scratch, so I think that is relevant in your consideration. Their engineer, special reasons and purposes of zoning, they call them different things. They're the same things in terms of the testimony you hear. Purposes of zoning, light, air, and open space, that kind of stuff. So the board engineer went through a bunch of purposes. One of the important ones is preserving historic structure and maintaining it, and they are doing that. Do you have HPC approval?
Conceptual.
They have conceptual HPC approval. I'm not sure that was mentioned, but they have conceptual HPC approval. So they've advanced certain purposes of zoning, which they considering special reasons for purposes of this application. They still have to satisfy the negative criteria. What is the impact on the zone plan and zoning ordinance, and also on the neighborhood in general, and particularly people within 200 feet. You heard the testimony of the witness. His and her testimony are principally directed at the fence. not as much at the two uses. So I need you to give consideration as to how the thing that they're doing impacts the zoning ordinance in the neighborhood. So that's the standard that you're going to apply to this application. So the motion, and because they presented it as a whole, you're going to vote as a whole. So it needs 5 out of 6 for this project to be approved. So the motion I recommend being made is a motion to grant the variances. The variance is listed on page 4, use variance and lot coverage, subject to the conditions, the waivers outlined by the board engineer. The waivers were numbers 2 and 19, and then 23, I'm missing a 3, 23, 26, and 28. Conditions, number 5, number 20, and then 1 through 11. But with regard to the Shade Tree Commission, they are going to they're going to construct the landscape plan that they've given you, which is, your engineer said was substantial, in lieu of some of the concerns expressed by the Shade Tree Commission. That's the motion I recommend being made. How you vote is up to you. They need 5 out of 6 to succeed. As Catanese was told ahead of time, we only had 6 members, so they're kind of taking their chances a bit, because sometimes if there's 7, they got an extra chance of getting the 5. So as you vote, keep in mind that 2 noes reject the application. Again, that's how you vote is up to you. That's the motion I recommend being made. Any questions?
Okay, someone make the recommendation, or the motion?
Motion.
Motion.
Okay, we have a motion by Mr. Zexer, seconded by Mr. Cataldo. Mr. Ledwin?
I empathize with the neighbors, and I'm sorry that we weren't able to come to a compromise of a 4-foot fence. But if it's legally for them to be able to do the 6-foot, I would vote yes.
Mr. Walsh?
I have to vote yes, too, but I would implore you to try to work something out here.
Mr. Zexer?
Yes.
Mr. Cataldo?
I also vote yes and have the same view that a compromise could have been reached for a 4-foot fence or a fence with lattice or a fence similar to the way that the neighbors could get along. Good fences make good neighbors, but in this case, it may not be the case.
Mr. Bodnar?
I share the same views as my colleagues on the board. I'd like to see if they can try to work something out here, but I vote yes.
Mr. Venuto?
I vote yes, and I agree with what everyone has said.
Thank you.
Thank you all for your time. Have a
All
great
right,
night.
thank you.
Thank you.
I do have to talk about.
All right, we have unfinished business, because we have people that need to get paid, so.
I do have to say one, oh, that's stuff like, sorry. I got to talk about something.
So we need a motion for this, John?
Yes.
Yep.
So it's a new procedure that my new boss wants the board, so you each got a list with your packet of the bills, and he just wants to make sure that the board's aware of the bills and wants you to approve the bills. So the chair or the vice chair can sign, but someone wants to make a motion that you authorize him to sign, then we can get the bills paid.
So move.
Do we have a second?
I'll second it.
Okay, we have a motion by Mr. Ledwin, seconded by Mr. Walsh. Mr. Ledwin?
Yes.
Mr. Walsh?
Yes.
Mr. Zexer?
Yes.
Mr. Cataldo?
Yes.
Mr. Bodnar?
Yes.
Mr. Venuto?
But it's
Yes.
Thank you.
Only the ones that deserve it.
Well, he's invoiced but not paid?
All right, one thing, are you done with that? Yes. I just want to talk for a second about litigation that I was handling for the board. And I haven't given it a lot of thought, so I'll give you the best summary I can. If you recall, we had an appeal of the locale you, what? Locale Stockton. I'm trying to recollect it all, I'm kind of tired. Okay, I got it now. The HPC denied Locale's request to have their approval amended to be the as-built version of the hotel in certain respects. That came before us on an appeal. We made a couple of decisions. The first one we made was that we said they couldn't introduce a new expert without that expert having testified before the HPC. We then heard the application and we affirmed the HPC's decision. They appealed that. It was an important appeal for the city of Cape May, in my opinion, because it was a challenge to the entire way that we conduct our HPC review. They didn't feel that we should be, they basically wanted it so that they could go to the HPC, have a hearing, and then come here and have like a new hearing, a second bite at the apple. And Judge Blee rejected that entirely, and he supported the system, our ordinance. They challenged our ordinance, the propriety of our ordinance. And I, impressed upon the court that the HPC does things that we wouldn't be able to do without the HPC. We don't determine, bric-a-brac and the shape of railings, things like that. That's not even in our purview. The only reason that stuff even is ever discussed by us is on an HPC appeal. So it has to go to the HPC where there's people that are appointed with expertise for them to hear it, and then we will look and see if they, considered their guidelines and listened to the testimony, and basically whether or not they did their jobs in a reasonable way and didn't act arbitrary and capricious. But that wasn't how the applicant viewed it. They viewed it as us having abrogated our responsibility as a zoning board by letting the HPC do these things. And we won that. We convinced the court that our ordinance is proper. We also convinced the court that we didn't have to listen to an expert that the HPC hadn't heard. Our ordinance is clear, that's supposed to be on the record below, and that they should have their experts testify to the HPC's experts, because we're not in a position to necessarily judge their technical stuff. And so we won. Our board won. Now, there's still an issue lingering about the estoppel issue, and the city is still involved in that. I tried to pry us out of the case entirely. I'm still not entirely clear why we're still in the case, but we're still in it, but I'm not doing anything because Chris Gillen-Swartz is going to deal with the estoppel arguments on behalf of the board, and that's going to do whatever it does, and the judge will make a decision. But the judge issued a written decision supporting both our ordinance and our decision, okay? So I thought it was an important thing. Oh, they may. Well, no, as you may recall, Counselor, you cannot appeal until all issues as to all parties are resolved. That would be interlocutory, yes. So until they decide the estoppel issue, the time for the appeal hasn't begun to run.
So it might come back. It's bottom line. Once it's all done, they could take.
They could appeal it back up. Yes, they absolutely could. They could appeal it to appellate division, then I'd have to defend it there as well. Well, for now, you take the wins when you can. Okay?
Good job, Rich.
Well, I have a perfect record for both my boards. It is in jeopardy we will see how we do in the Valentine case, the pool case, that we just argued that one last week. See how that one goes. But as of now, no decision of any of my boards has ever been overturned. Once it got overturned by Judge Mendez, and then the appellate division reversed Judge Mendez and upheld the board's decision. So, but I've jinxed it, and we will surely lose the next one, but that's okay. That's it. That's where we are.
Yeah, but everybody should know just how hard it is to get something reversed on appeal, because most appeals don't get reversed. So.
It was harder than you know. Judge Mendez reversed my board, and then Judge Nugent, who is from Atlantic County, was the appellate judge. And it was only a 2-judge panel, and they still reversed them. So for technical reasons, that's kind of a rare thing. There's supposed to be 3 judges. When there's 2 judges usually assigned, they're not going to reverse. They're going to affirm, because rarely do you get a reversal with only 2 judges and the two-judge panel reversed, so that was a different time. All right, there you go. You want to talk? Okay, go ahead.
You know, we had a condition.
Turn on your microphone, we're on the record.
We had a condition of approval for the unit up on Beach Avenue for a gate, you know, the parking
Yes, we
underneath.
talked about that last time, there wasn't a gate there.
There's still no gate.
It's been ordered. It was back ordered.
Okay.
Stay tuned.
All right.
I think they might regret the gate once it's up. I think it looks nice without the gate, and putting a big gate there, to me, seems the opposite of historic. When you look at that, you look right through to the building in the back, it looks kind of cool, and you don't see the cars.
I reached
So,
out to them, and they're planning on putting it up.
yeah,
And that's, at least verbally.
it's on Beach. What's the address?
It's
It's not.
933
What's the
Beach.
Seamist, I think.
Oh, it's a
933.
Oh, Hana. I just raised it because it was a condition of approval.
It was, yeah. A couple meetings ago, I had gone by on my bike and mentioned it, that I'd gone down there, and
Okay.
I'd come to the
I followed
conclusion.
up, and
All right, do we have a motion to adjourn?
I'll make that.
I'll second.
All in favor?
All right.
All right, good night, everyone. Thank you.